Godātie konferences dalībnieki, man ir tiešām liels gods atklāt šo konferenci, kura ir veltīta ļoti aktuāliem jautājumiem, jo mēs dzīvojam tādā pārmaiņu laikā. Tas nebūs pārspīlēts, un šīs konferences tieši pirmā rīta sesija ir veltīta tādu notikumu analīzē, kur, es domāju, ietekmēs Eiropas tuvāko un tālāko attīstību. Es esmu profesors Rozentāls, un man ir uzticēts vadīt šīs rīta sesijas norisi. Lūdzu pārliecināties, ka visiem ir šīs tulkojamās ierīces, kas ir iegūstamas tur ārpusē. Tātad, ievadot šo konferenci, man ir tas gods nolasīt valsts prezidenta rakstveida apsveikumu šai konferencē. Apsveikums Latvijas Universitātes Juridiskās fakultātes 6. starptautiskās zinātniskās konferences konstitucionālās vērtības mūsdienu tiesiskajā telpā atklāšana. Latvija, Eiropa un pasaule šobrīd saskaras ar daudziem izaicinājumiem, kuriem ir nepieciešams rast jaunus un radošus risinājumus. Šajā laikā jo īpaši svarīgi ir atgriezties pie vērtībām, kas nosaka mūsu sabiedrības kopējos pamatus un piešķir jēgu mūsu darbam. Mūsu vērtības un Latvijas valsts iekārtas pamats ir demokrātija, cilvēka pamattiesības un likuma vara. Šīs vērtības mums ir kopējas ar citām Eiropas Savienības valstīm un nosaka mūsu piederību rietumu tiesību telpā. Mūsu vērtības ļauj nošķirt pareizu un kļūdainu rīcību, taisnīgu un netaisnīgu lēmumu. Tās ciešāk iezīmē un ļauj atpazīt mūsu draugus, ar kuriem kopā varam rast atbildes globāliem izaicinājumiem. Juristiem šajā izaicinājumiem pagātajā laikā ir īpaša misija aizsargāt un nostiprināt demokrātijas, cilvēka pamattiesību un likuma varas nozīmi sabiedrībā un valstī. Latvijas Universitātes Juridiskā fakultāte vēsturiski ir tiesiskās domas, tiesību zinātnes un juridiskās izglītības centrs Latvijā. Tas jums uzliek papildus pienākumus un atbildību par mūsu tiesisko sistēmu. Tiesību zinātne nebeidzas ar Latvijas robežām. Latvijas tiesību zinātniekiem nepieciešams aktīvāk iesaistīties tiesību attīstībā Eiropas un starptautiskā līmenī. Mums ir vajadzīga zinātnieku pārobežu sadarbība kopīgos projektos un starptautiski atzīti pētījumi, kas Latvijas vārdam ļautu izskanēt Eiropas un pasaules juristu diskusijās. Lai šī konference jums sniedz jaunas idejas un radošas iedvesmas turpmākajam darbam. Lai kopējās diskusijās rodas pamats jauniem rakstiem un pētījumiem. Lai jums visiem veiksmīgs darbs. Raimons Beigonis. Paldies! Juridiskās fakultātes dekānas asistētās profesors Anitas Lodiņas Uzina. Lūdzu.
Godātais prorektori, godātais Satversmes tiesas priekšsēdētāji, cienītā Eiropas tiesību institūta prezidenta, godātie profesori, godātie tiesneši, dāmas un kungi. Man ir liels gods un lepnums sveikt jūs mūsu fakultātē un šodien atklāt konferenci, kas veltīta konstitucionālo vērtību pētniecībai. Šonedēļ Latvijas svin 98. dzimšanas dienu. Šī nedēļa ir valsts svētku nedēļa. Un šķiet, ka nav labāks laiks, kad runā par vērtībām mūsdienu mainīgā un izaicinošā pasaulē. Valsts svētku, valsts esība acīm redzam liek apstāties liek paskatīties un liek vērtēt un novērtēt to, kas mums ir dots. Mūsu valsts neapšaubām ir vērtība. Prieks, ka šī vērtība arvien biežāk tiek norādīta kā slavējama un uzteicama. Izcīnīta, nevis dāvināta, kas tālāk sargājama un kopjama. Arī satversme, mūsu konstitūcija, ir vērtība. Vērtība tā vispirms ir pati par sevi, kas līdztekus aptver tiesību normas, principus un nākotnes orientierus. Vērtība ir arī zināšanas, kompetences, zinātnība un zinātne kā tā ir vērtība. Šodien šīs visas vērtības satek kopā, veidojot fundamentālu notikumu mūsu konferenci. Juridiskā zinātne, lai arī ne kā prioritārs zinātnes virziens Latvijā, tomēr caurauž visu mūsu valsts attīstību kopumā. Bez atbilstošā līmenī veikta zinātniskās darbības jurisprudences laukā nebūs iespējams sasniegt visus valsts un arī Eiropas Savienības brīžiem šķiet ambiciozos mērķus un plānus. Nebūs nec stabila un prognozējama tiesiskā vide, nec ekonomiskais izrāviens, nec inovācijas, ja iztrūks juridiskais šo jautājumu tvērums. Ir teikts, ka zinātnieks nedrīkstētu būt savdabs, jo rezultātiem jābūt lietojamiem. Bet vai kādam ir šaubas par to, ka juristi un mūsu fakultātes zinātnieku veiktais darbs un tā rezultāti nebūtu praktiski lietojami? Vai varētu pastāvēt tiesībās balstīta valsts bez mūsu veikuma? Vai būtu iespējams sasniegt šos cēlos vērtību orientierus mums paveiktā? Godātie kolēģi, Juridiskā fakultāte ir, bija un būs līderis juridiskā zinātnes virzīšanā Latvijā. Viennozīmīgi var piekrist starptautiskajiem ekspertiem, kuri atzinuši mūsu spējas un varēšanas būt par līderi nacionālās tiesībās. Šī konference ir spilgts apliecinājums tam, ka mums ir ar ko lepoties un mēs varam būt atvērti Eiropas un pasaules zinātnes telpai. Mēs varam debatēt un spriest ar mūsu kolēģiem no citām valstīm. Mums ir ar ko dalīties, un tāpat laikā mums ir ko mācīties. Vērtību aktualitāte nozīme to saturu visdažādākās juridiskās zinātnes apakšnozarēs. Šajās 2 dienās būs iespējams šķetināt un līdzdarboties plenārsēdē un arī 9 sekciju sēdēs. Kopumā šajās 2 dienās tiks nolasīti 57 referāti un apspriesti 37 stendu referāti. Līdztekus tam profesora programmu vadītāja ekoloģija vasarā ir paveikusi lielu darbu, kas apkopots konferences materiālu krājumā, ko jau tagad jums visiem ir iespējams turēt rokās. Šis rakstu krājums jau ir iesniegts indeksēšanai starptautiskā datu bāzē. Tuvākā laikā tiks sagatavots arī otrs krājums, kuru mērķi ir nedaudz ambiciozāki. Es ceru, ka katrs no jums spēs atrist, ieraudzīt nākamo pētniecības periodu izaicinājumus, sadarbības jomas un iespējas, lai konferencē uzsāktais darbs turpinātos nākamajos darbos. Godātie konferences dalībnieki, ievērojams latviešu literāts un sabiedrisks darbinieks Kārlis Skala reiz ir teicis: taupiet cilvēku, dārgāks par visu ir cilvēks. Proti, pat cēlākā vērtība ir cilvēks. Ja cilvēks ir pamatvērtība. Juridiskā fakultāte bez cilvēkiem, bez maniem kolēģiem būtu tukša skaņa. Tā skaitā šī konference ir kopīgs komandas darbs. Tādēļ vēlos pateikties šīs konferences organizatoriskajai komitejai, redkolēģijai, kas apvienoja kolēģus no visdažādākām Eiropas valstīm un universitātēm. Paldies arī fakultātes atbalsta personālam par paveikto, kā arī studentiem par iesaistīšanos konferences norisēs. Es vēlos pateikties arī mūsu atbalstītājiem Latvijas gāzei un personiski Kalviešu kungam par atsaucību, izpratni un atbalstu. Un milzīgs paldies visiem referentiem, konferences dalībniekiem, kā arī mūsu viesiem, kas mērojuši tālu ceļu no Grieķijas, Beļģijas, Lielbritānijas, Itālijas, Vācijas, Polijas, Lietuvas, Igaunijas, Čehijas, Gruzijas, Spānijas, kopumā 15 valstīm. Un kā liecina pieredze, nav vajadzīgi nedz oficiāli līgumi, nav nozīmes attālumam. Galvenais ir jābūt gribai un vēlmei būt un piedalīties. Un visbeidzot, Pētījumos ir secināts, ka Latvijā trūkstot vērtību noteiktības, trūkst ilgtspējīgi mērķi. Vienlaikus ir atzīts, ka Latvijas nākotne ir mūsos, proti cilvēkos. Tādēļ vērtības, jeb šīs visas jābūtības meklēsim vispirms sevī, savos darbos, savos tuvākajos un apkārtējos un savās iecerēs. Lai mums visiem jaukas un izdevušās pirmsvētku dienas, kurās pavadīsim šeit mūsu alma mater un veltīsim vērtību pētniecībai. Paldies!
Paldies dekānei par iedvesmojošo uzrunu. Latvijas Universitātes prorektora, sociālo un tiesību zinātņu jomā profesora Jāņa Ikstena.
Good morning, ladies and gentlemen. Welcome to the University of Latvia. It is my true pleasure to welcome not only my esteemed colleagues from the University of Latvia, but also distinguished scholars, legal scholars from countries all over Europe. It has been already mentioned several times that we live in times of change, that we live in challenging times. I certainly agree with that. I think we witness a resurrection of values. We witness a resurrection of the role values play in both public domain and private sphere as well. And moreover, we witness a clash of values that perhaps can only parallel the advent of Christianity about 2,000 years ago in Europe. Therefore, I certainly applaud the organizers for choosing this topic, and I believe it will even more contribute to the liveliness of debates. It will contribute to the vigor of debates in the atmosphere of academic excellence that has been a trademark of the Faculty of Law and the University of Latvia in general. Therefore, I wish you interesting and challenging conference. Thank you.
Thank you very much. Parallel with advent of Christianity was impressive. Nākamais tātad ir Latvijas Republikas Satversmes tiesas priekšsēdētāja Alda Lavina. Lūdzu.
Labrīt, cienējamā dekāns kundze, godātie profesori, tiesneši, cienējamās dāmas, godātie kungi. Man ir patiesa gods uzrunāt jūs konferencē, kas veltīta tematam par konstitucionālajām vērtībām, to nozīmi un vietu mūsdienu tiesiskajā telpā. Vispirms es gribu atzīmēt, ka konference un diskusija par konstitucionālajām vērtībām notiek ļoti nozīmīgā laikā priekš Latvijas. Tā kā šī ir starptautiska konference, es atgādināšu, ka novembris Latvijai ir mēnesis, ko mēs pavadām un uzskatām par mūsu svētku mēnesi, jo tas iezīmē mums vairākas svarīgas vērtības. 1918. gada 18. novembrī tika nodibināta mūsu valsts. Tieši novembrī 1919. gadā tika izcīnītas izšķirošās brīvības cīņas, lai jaundibināto Latvijas valsti nosargātu. 1922. gadā brīvi ievēlētā satversmes sapulcē tika pieņemta satversme, un novembrī tā stājās spēkā. Un visbeidzot, pirms 18 gadiem tieši novembrī stājās spēkā ļoti būtiski Latvijas tautai satversmes grozījumi, jo tika pieņemta pamat tiesību nodaļa. Es vēlos uzteikt konferences organizētājus par ļoti veiksmīgi izvēlētu tematu konferencei. Kolēģi, mēs visi zinām, ka konstitucionālās vērtības ir konstitucionālā ietvara stūrakmeņi. Un kā tādas, konstitucionālās vērtības ir fundamentālas un stabilas. Tomēr man jāteic, ka var būt noteikti apstākļi, kas var ietekmēt konstitucionālo vērtību, saturu un izpratni. Tiesību zinātnieki teica, ka tas, ka vērtību izpratni var mainīties, nav nekas slikts un ļauns. Tieši otrādi, tas ir veids, kādā konstitucionālā sistēma spēj reaģēt uz jauniem izaicinājumiem. Un no šāda aspekta raugoties, es domāju, būtu interesanti šīs konferences ietvaros dzirdēt diskusijas, kā mūsdienu globalizācijas apstākļi ir ietekmējuši sabiedrības attīstību un kādā veidā tie ir ietekmējuši arī mūsu konstitucionālo vērtību izpratni. Otrs aspekts, ko es gribu minēt saistībā ar to, ka veiksmīgi ir izvēlēts konferences temats, es atkal gribu teikt, kolēģi, mēs visi ļoti labi zinām, ka konstitūcija ir mūsu tautas kopējā gribas izpausme, jeb citiem vārdiem, tas ir mūsu sabiedrības kopējs līgums pašiem ar sevi par to, kas ir mūsu pamatvērtības un kā mēs pārvaldīsim mūsu valsti. Un šis aspekts par sabiedrības kopējo konsensusu vai līgumu ir ļoti būtisks, jo tas norāda, ka pašai tautai un tās priekšstāviem ir jāievēro konstitūcija un tās pamatā liktās konstitucionālās vērtības. Pirms pusotra gada kādā no konferencēm es minēju, ka dzīvojam trauksmainā laikā. Un tajā reizē es šo trauksmainības aspektu minēju tā iemesla dēļ, ka ne jau tālu no Latvijas robežām, pielietojot militāru spēku, tika mainītas valstu robežas. Šobrīd es teiktu, šī trauksmainība nav mazinājusies, manā skatījumā tāpat vēl ir palielinājusies, jo ir parādījušies jauni izaicinājumi. Un šie izaicinājumi rašanās vieta, es teiktu, atkal nav tālu no mūsu valsts robežām. Un šie izaicinājumi ir saistīti ar demokrātijas izpratni. Mēs zinām, ka demokrātijas pamatā ir princips, ka vairākums pārvalda sabiedrību. Bet, kolēģi, vai tas nozīmē, ka politiskais spēks, kas demokrātiskās vēlēšanās ir ieguvis absolūto vairākumu, var īstenot tikai savus politiskos uzstādījumus un nerēķināties ar konstitūcijā ietvertajām pamatiesībām? Manā skatījumā nē, un es domāju, ka par nepieciešamību ievērot konstitūciju un konstitūcijas pamatā liktās vērtības noteikti varētu atgādināt institūciju, kuras uzdevums ir gādāt par konstitūcijas aizsardzību. Un, kolēģi, ko darīt situācijā, ja politiskais vairākums vēršas pret šo institūciju? Lūk, parādās tad aktuāli jautājumi, vai mūsdienās tā ir kļuvusi par pašsaprotamību, ka politiskais vairākums, tautas priekšstāvi labprātīgi ievēro konstitūcijas pamatā liktās vērtības? Un kas ir tas konstitucionālais regulējums, kas pat krīzes laikā varētu nodrošināt efektīvu konstitucionālo vērtību aizsardzību? Kolēģi, es ceru, ka šīs konferences ietvaros šie jautājumi un arī vēl citi jautājumi tiks diskutēti, un tiesību zinātnieki, kolēģi, kur jūsu pienesums tam, lai stiprinātu tiesiskumu, ir ļoti būtisks, es ceru, ka jūs dalīsieties savā viedumā, dalīsieties savās idejās un piedāvāsiet dažādus interesantus risinājumus attiecībā uz mums interesanto tematu. Un noslēgumā es gribu pateikties Latvijas Universitātes Juridiskajai fakultātei par ieguldīto darbu šīs konferences organizēšanā. Un sirsnīgi gribu pateikties, ka ir speciāli izveidota sekcija, kas veltīta tieši Satversmes tiesas 20 gadu darbām. Paldies! Un noslēgumā vēlu veiksmīgu un atziņām bagātu konferenci. Paldies!
Paldies Aldiņam Laliņam. Eiropas Tiesību institūta prezidentas Dejana Vallis uzruna.
Good morning, ladies and gentlemen, and I should say, first of all, thank you so much to the university here for inviting me to be part of this opening ceremony at a conference that, in my view, couldn't be more appropriate or timely in the issues which you are discussing. I am privileged to come here as the president of the European Law Institute. We may be a completely unknown institute to some of you, so let me just take a moment to explain. We are modelled on the American Law Institute, which has a history now going back some 90 years or more, and has been influential in assisting the development of American law. Our mission is exactly the same, although we are only 4 or 5 years old. To bring together Europe's legal community, so academics, judges, practitioners, in the widest sense, that community, to help the development and the betterment of European law. And, of course, constitutional law at the moment and values, certainly in my own home country of the United Kingdom, are very much in the press. People are dusting down old volumes on constitutional law, looking at cases that date back to our civil war in the 17th century. So I just wanted to share a few thoughts with you, because I think as Europeans we had the sense that constitutional rights, values like the rule of law, were universal, were global. But those assumptions, underpinned as they are by the treaties of the European Union, are now being perhaps called into question. You know, we had always thought that progress, as it were, went on a linear basis, but perhaps nowhere more than here, as you celebrate this week your independence. You realise that things can go backwards, they can stall, and then you move forwards again. And perhaps we are in a period like that, who knows. But when I look in my own country, we do not have, as you know, a written constitution, but last year we celebrated a very important centenary of Magna Carta. And now, just a year on, we see headlines in our press that show pictures of our leading judges as, quote, enemies of the people. It's a bit scary. Of course, we all realise as lawyers that you have to balance the independence of the judiciary along with the freedom of the press. But perhaps this has gone a little too far. It's very, very worrying. And then we watch events in America, and we see perhaps the very partial appointment of judges that is likely to occur in the near future. And certainly the independence of the judiciary seems under threat. And that is key because, you know, Tom Paine said, the law is king, but what is happening if the people that are interpreting the law in our courts are not given full independence and trust? I also, I suppose perhaps in an idealistic way and reflecting on your title, thought Well, it's interesting. Some of us in the United Kingdom, well, nearly half of us that voted in our recent referendum wanted to remain part of the European Union, wanted to have access to European Union rights of citizenship and other values. And it's interesting, in the last week, a member of the European Parliament has proposed a constitutional amendment that will allow citizens of European states which cede from the Union to continue to enjoy rights of EU citizenship. Now, it may be fanciful and it may come to nothing, but it's an interesting idea in a contemporary legal space. Can I, as it were, can we pack up our rights in a rucksack on our back and carry them with us as we move around Europe? That would be an interesting idea. Because there is no doubt that some of our values are under threat. I'm privileged in the role I enjoy to travel around Europe, to discuss with lawyers, to see places as a teenager in Europe that I never dreamed I would visit. We have enjoyed and begun to have such freedom as lawyers. I hope we are not about to put up new barriers. But I wish you good and fruitful discussions. Thank you.
Paldies, Dianai Valks. Tieslietu ministrijas valsts sekretāra vietniece Irēnas Pusienas.
Labdien, cienījamās dāmas un augsti godātie kungi. Man šodien patiesi prieks atklāt un būt klāt ar jums šodienas konferencē un arī sveikt jūs Tieslietu ministra Dzimta Dāsniņa vārdā. Ļoti nozīmīgi, ka konferences noris šogad sakrīt ar Latvijai un latviešu tautai būtiskiem notikumiem. Pirms 98 gadiem tika izveidota Latvijas tautas padome, kura nākamajā dienā, 18. novembrī, proklamēja Latvijas valsti. Līdz ar to arī konferences dalībniekiem nebūtu nav jāskumst, ka rītdien šī konference būs noslēgusies, jo nākamajā dienā mums ir skaists notikums – neatkarības dienas svinības. Tāpēc, izmantojot manu ministra kungam doto iespēju šodien sveikt arī jūs Latvijas dzimšanas dienā. Atgriežoties pie konferences temata, šogad tas ir veltīts tieši konstitucionālajiem jautājumiem. Mēs iespējams esam pieraduši pa laikam dzirdēt dažādus aicinājumus atgriezties pie mūsu saknēm, pie tām vērtībām, kādas pastāvēja Latvijas valstiskuma proklamēšanas brīdī. Tas nevienam vien līdzis uzdot jautājumus, vai mainās vērtības un vērtības sistēma, vai maināmies arī mēs paši. Taču nevar noliegt arī globālas pārmaiņas un to, ka pēdējos gados novērotais pasaules demokrātijas vērtību apdraudējums ietekmē arī Latvijas tiesību telpu. Tāpēc konstitucionālie jautājumi mūsdienās šķiet ir kļuvuši aktuālāki nekā iepriekš. Šis gadsimts pasaulē ir iezīmējies ar masveidu bēgļu pārvietošanos, ar Brexit un ar gaidām no tā, ko nesīs arī Amerikas Savienoto Valstu vēlēšanu rezultāti. Ja pat Latvija pēdējā laikā nav skāruši kādu nozīmīgi satricinājumi, tad tas nenozīmē, ka Latvijā neatbalstosies notikumi arī Eiropā un pasaulē. Mēs juristi šos procesus dēvējam par pārmaiņām, kas liek uz notiekošo palūkoties no tiesību socioloģijas viedokļa un atgādina visiem, ka tiesības ir dzīves. Tāpēc arvien atkal un atkal mēs atgriežamies pie tiesību esences, pie mūsu konstitūcijas. Tajā ir atrodams noregulējums valsts pamatiem, tajā ir iekļauts pamatiesību katalogs, tā sakur zīmes par valsts izveidošanas un pastāvēšanas principiem, izvirza valsts nākotnes mērķus. Ceru, ka pēc šīs konferences mēs visi kopā skaidrāk spēsim arī prognozēt iespējamos notikumu virzību, lai pārmaiņas mūs nepārsteidz nesagatavotas. Es varu ar gandarījumu konstatēt, ka atbilstoši konferences programmai šo 2 dienu laikā mums būs iespēja dzirdēt ne tikai Latvijā pazīstamus un ekscelentus tiesību zinātniekus, bet arī viesus no daudz dažādām valstīm. Esmu pārliecināta, ka šīs 2 dienas visiem klātesošajiem paies ļoti skaistā gaisotnē, tiesību zinātņu gaisotnē, jo šie jautājumi, kas šodien tiek skatīti, ir ļoti nozīmīgi un paver daudz un dažādu plašu spektru, ko konferences laikā tiks apskatīts. No savas puses gribēju pateikt paldies Anitai un visai Anitas komandai, jo personīgi man ir liels prieks vienmēr atgriezties Latvijas Universitātes Juridiskajā fakultātē, kas ir ļoti mīļa arī man, jo šeit ir mūsu tiesību zinātņu pils un par tām zināšanām, ko mēs šeit esam ieguvuši. Lai veiksmīgi konferenci!
Paldies, Irenai. Līdz ar to tātad atklāšanas ceremonija ir noslēgusies, un mēs pārējām pie konferences pirmās sesijas darba. Un mums ir ārkārtīgi saspringts grafiks. Lūdzu vērst arī runātāju uzmanību uz to, ka mums ir ļoti stingri jāiekļaujas 20 minūšu reglamentā, jo mēs nedrīkstam nokavēt arī neko no nākamajiem pasākumiem, tā skaitā arī pusdienas. Līdz ar to tātad es, pārējot pie konferences programmas, tagad došu vārdu runātājiem Jāpu Svānu, un referāta tēmats ir Eiropas Savienība piedzīvo vairākas krīzes. Viena no tām ir Brexit vai nepieciešamas reformas ES konstitucionālajās struktūrās. Man ir tas gods iepazīstināt jūs ar runātāju. Zvana kungs ir Erasmus Universitātes Rotterdamā profesors, iepriekš bijis tātad Rotterdamas Law Network priekšsēdētājs un institūta direktors. Institūts ir Slingendael, dzīvais Berlīna laikā. Tas ir Nīderlandes starptautisko attiecību institūts. Lovis Vels.
All these extra facilities. Right. Well, Mr. Chair, Madam Dean, thank you very much for the invitation to be here during a week full of celebrations. So congratulations to you all for the state independence celebration this week. I'm impressed about all the historic achievements of your country, first independence, 1918. And now we are discussing the role and position of Latvia as a member of the European Union, because we start with serious business. And I'm also bound to this very narrow time limit of 20 minutes. However, I want to raise some fundamental issues. And that's why I thought it would be practical to at least present one slide to give you the structure, and hopefully for the students who are, I think, upstairs, I hope this will give them also some assistance in following a very concise presentation. There was already a first reference to Brexit. But let me say the following, point one. The European Union, for a long time, has been a stable and safe organization. However, she is now under serious threat. External challenges affect the stability of the Union. To mention a few issues: the migration crisis, the tensions at our eastern borders, you're very close to them, the conflict Russia-Ukraine, situation in Turkey, troublesome, continuing conflict around the Mediterranean, Israel-Palestine, conflict eternal, it seems, Syria, horrendous atrocities during the civil war, Libya, a country in transformation which has not as yet found the right direction how to operate, and terrorism. which is a very sincere threat for our public order and for our lives of our citizens as well. And indeed, since last week, we also have to mind the maintenance of good relationship with the United States. Now, Donald Trump has been selected as its 45th president. However, the Union's cohesion is also challenged from the inside. The economic crisis, I think Latvia is doing a very good job with regard to economic development, economic growth, but in many countries, the economic crisis is not over yet. Several member states, especially those in the south, are suffering disproportionately from the influx of migrants. Populism is progressing in many member states, and governments of many, I dare to say, member states are involved in discussions about the violation of fundamental EU values and principles. Finally, but not least, the citizens of the United Kingdom have voted recently to withdraw from the European Union, so the Brexit enterprise. And the discussions how to organize the European Union's future has started now during a summit meeting in September in Bratislava, the future agenda of the 27th. Second point, European Union is supposed to act as an entity, act and behave as an entity. Every member state, all 28, participate in the process of policy making and decision making about given proposals. Once a decision has been taken, all member states are bound to the content of decisions, are also obliged to implement the text, and they are under control with regard to the modalities of implementation. Respect for the unity dogma has been justified from the outset by the necessity to establish the common markets, the core business of the EU. A common level playing field had to be established in which the same rules have to be applied by and enforced by all member states. An independent institution, the European Commission, has to check its implementation, and the rules are interpreted in a uniform manner by a single authority, the Court of Luxembourg, in the Court of Justice in Luxembourg. Now, certainly, we have experienced deviations from those principles of unity and uniformity in practice. To number a few, the United Kingdom and Denmark have been granted derogations to participate in Euro cooperation. The United Kingdom, Ireland, and Denmark are not participating in the area of freedom, security, justice cooperation, the opt-out, opt-in system. And the United Kingdom, it's always United Kingdom is this list of countries, and Ireland have a derogation with regard to the Schengen cooperation. You are in, I think, fantastic achievement. And in other domains, specific conditions have to be fulfilled in order to be able, as a member state, to join a common policy field, such as, again, the Euro cooperation. Now, I want to turn to an issue which is the principle of enhanced cooperation. The Amsterdam Treaty, which entered into force in May 1999, I happened to be part of the presidency team at that particular moment, introduced the principle of enhanced cooperation. This principle allows, in the end, at least 9 member states to further the objectives of the Union, to protect its interest and reinforce the integration process, in a situation where it's not possible, after a reasonable time of negotiation, to find a common agreement in the Council on a specific proposal. So it's an instrument as a kind of last resort. No common solution being possible, at least there is a possibility to create a forerunners group. However, still, unity and uniformity are still the fundamental principles of our EU law and policy. The third point. The question arises now, whether these principles can be maintained in a situation where we found ourselves in, and which I sketched at the beginning of my presentation. I think that is clearly not the case, and for that reason I want to present you some challenging proposals. Let me first dwell upon the reasons why I think we have to change in the constitutional area also some of our principles. The number of member states, first point, has increased significantly over the time. That certainly is a great achievement, perhaps the greatest achievement of the European Union, to have so many European states on board. However, the group of member states is not that homogeneous anymore as it was in the early days. And still there are newcomers to come, the remaining successor states of former Yugoslavia. Again, wonderful achievement, however, important substantive differences do exist between those states and present member states. In the first place, certainly with regard to their economic development. Secondly, the scope of EU objectives and competences has substantially enlarged over the years. We started with the internal market, agriculture policy was in, transport policy was in, later on environmental policy, research has been added, and since the entry into force of the Maastricht Treaty, at that time I was a member of the legal service in The Hague, crucial but politically very sensitive complementary domains have been added to the list of responsibilities of the EU, common foreign and security policy on the one hand and justice and home affairs on the other. And also the Maastricht Treaty introduced the modalities for the economic and monetary union and so forth. So the list has been a rather impressive one. Also we have to note, third point, that not all member states apparently, United Kingdom in the first place, anywhere to cooperate in this process and to make further steps in the process of integration. National economic policies have to be approximated, however, results are minimal. Asylum and immigration, we have noticed in practice, a couple of member states simply refuse to implement the decisions commonly made. And another tendency is connected to Euroscepticism. We have to recognize an increasing number of citizens believe that the integration process has advanced too far, that its scope has become too wide, and that time has come to review the appropriateness to hand over new responsibilities to the EU. And Euroscepticism has led to the rising of Eurosceptical political parties and even to the upcoming of a number of Eurosceptic governments in a number of member states. And finally, but not least, of course, the reference again is to Brexit. The situation of a member state whose population apparently is not willing anymore to cooperate further on the path of deeper integration. So all these arguments, in my perspective, indicate necessarily and realistically that we have to look for mechanisms of flexibility and differentiation. And these are the two proposals I would like to make. Enhanced cooperation is the first one. We have to try to simplify the conditions for that. And also, my proposal is to simplify the procedures for treaty amendment. With regard to enhanced cooperation, I would like to say in the first place that practice shows that the conditions under which enhanced cooperation is of application are very difficult to apply. A mandate, an explicit mandate of the Council upon the initiative of the Commission and with the consent of the European Parliament is required in order to allow this group of member states, at least 9, to advance. However, in a situation where it has appeared not to be possible to find common ground in the Council negotiations to start with. Certainly, these conditions, difficult as they are, have been imposed on purpose, namely to avoid that the core business of the European Union will be negatively affected by unilateral approaches of groups of individual states. However, the question arises whether we should not try to simplify the conditions to trigger enhanced cooperation. My proposal in that respect is relatively simple. we should do away with the condition which is now set in the treaties, where the Council, upon a proposal of the European Commission, has to decide by qualified majority that enhanced cooperation can start off. And my proposal is also that we have to do away with this initiative to be submitted by the European Commission. Again, when the situation has become clear in a council negotiation, when the Commission brought this proposal, that a qualified majority, for example, cannot be found, in my perspective, after a reasonable period, we have to allow this smaller group of member states to advance. And in that connection, my proposal is that once the condition has to be fulfilled, that a number of member states represented a substantive part of the EU population willing to do so, they have to be granted the right to do that. That is a critical mass in which way we can indeed ensure that at least the enhanced cooperation is supported by a substantive number of member states as well. And certainly the results of enhanced cooperation in the end will be binding only on the participating member states. So by way of conclusion, in this respect, instead of raising obstacles in the process of implementation of the treaty objectives, my proposal is to rather create opportunities to facilitate that process. The second one is dealing with simplification of the treaty amendment procedures. The present rules and procedures have been laid out in Article 48, and the whole procedure from the start is governed by the principle of consensus. The opening of conferences has to be supported by the member states. The outcome of the negotiations have to be improved by all member states. They have to be signed by the represented by all member states. They have to be approved at the national level through ratification by national parliaments in all the member states before such a text can enter into force. So in practice, each and individual member state possesses a right to veto in all stages mentioned. And it's my plea that this situation should be simplified. My proposal in that context is that one can imagine that groups of member states, again, so the reference not to the totality, should be allowed to start negotiating to amend the existing treaty provision, sign them, and apply them between them. Once a substantive majority of member states, let's say 3/4 of the number of member states have approved them. So in the present instance, 21 out of 28 member states. Equally, such treaty amendment should no longer have to be explicitly approved at the national level. On the other hand, national parliaments should have the right and the ability to reject new treaty amendments once they have serious objections. And in that case, the member state concerned will not be bound. So the situation in future might become more complicated. However, the situation where we are in forces us, I think, at least to reflect, especially in an academic setting, about these kind of proposals. Are they justified? Are they appropriate? I can tell you they are fundamental in nature. When I was working in the ministry 20 years ago, these were completely out of the question kind of issues. However, forced by events from the outset, from the inset, I think we have to change now the ordinary structures. My perspective is essentially the one of the European Union, the objective subscribed to by all the member states. However, when they are not willing to participate in this process, we have to allow smaller groups to do that and to take the first steps. Because we should, in my conviction, also facilitate member states who want to make this first step to do that in the process of European integration. So, my plea to you is to reflect with me about the merits of these fundamental principles which were introduced for just good reasons. Stability, unity, etc., etc. However, in view of the circumstances of this period of time, I think it's high time to reconsider the merits of those principles. And again, nobody will be bound against its will. member state who does not want to participate will then not be bound. However, the group of the willing can move forward. My final remark concerns the position of Latvia in this discussion. I must say, from a perspective of a Western European country, as I can view the situation and development in this country, I'm very hopeful. Your country is a new member state, however also a very active member state, participating in all common policy domains, Schengen not excluded. You introduced the euro in 2014 and fulfilled the presidency of the Council of the European Union in the first half of 2015 with great success. I think that is quite an achievement. My hope, and as a final word on this, and expectation, let me add that also, is that a country like Latvia will be determined to profit as much as possible from all opportunities provided by the process of European Union cooperation. Thank you very much for your attention.
Paldies runātājiem, Jāpaslam. Nākamais runātājs ir Spiridons Logaitis. Viņa tēmats ir konstitucionālās vērtības ekonomiskās krīzes laikā Grieķijā. Spiridons Logaitis ir vienlaikus gan praktizējošais jurists, gan arī akadēmiķis, tātad Atēnu universitātes profesors, Eiropas publisko tiesību organizācijas direktors un vada vēl arī vairākas citas šāda veida sabiedriskās un juridiska rakstura organizācijas Eiropā.
Lūdzu. There is somebody in the audience who wants to put a question, I think. Or shall we do that later on? For me,
if it's possible, I would like to ask a question.
They are very squeezed in time.
Yeah, so
probably we would left the questions until discussion time. Sorry about that.
Dear President of the Faculty of Law, dear Secretary General of the Ministry of Justice, dear President of the Constitutional Court, I come from Greece, another small country which is in the other end of Europe when we are in Latvia, of course. I will talk to you in three parts. In the first part, I will explain to you in a few words what Greece is and what this society stands for. And this will help us to understand the third part, which is the crisis and what the constitutional values, what role they play in during the crisis. The second part will be, of course, a small introduction to the constitutional framework of Greece as it is in this period of the development of our nation. Well, I hope you will not laugh, but I will start my story about introducing you to Greece from the ancient times. I will remind you that Greece is an ancient nation, but the state is a young nation, a young state. This is an antinomy which is important in order to understand what is happening and what the solutions are. The Greeks live in this ancestral land for centuries, thousands of years. And at a certain moment they were conquered by the Romans. And then the Edict of Caracalla in 212 after Christ made of them Roman citizens. So since 212 we are culturally and ethnically Greeks. We were already Christians, and we defined ourselves as Romans. then we have the Roman Empire surviving in the east after the fall of the western territories, and with as a political center New Rome, as it was called, Constantinople, Byzantium, they call it more commonly. And this falls to the Crusaders in 1204, and then to the Ottomans in 1453. Between 1453, since 1853, the Greeks had more than 70 uprisings for liberty, and the revolution of 1821 was a glorious revolution. And in 1830, the first ever Greek state was created. A state which, according to those who made the revolution, should be modeled upon the states of our of the other civilized European states, and a state which was similar to the Napoleonic state of those days was established in Greece. This state was small. Only 1/5 of the Greek territory that you know was the state created in 1830. And ever since, in every generation, we made wars to englobe in this territory the ancestral land of the Greeks. And this process was completed as late as 1947, when the Deccanese, the Rhodes, the complex of the islands of Rhodes, perhaps you know Rhodes from your vacations, was liberated because we defeated the Italians. We have some Italians here. And they had to give us a land which did not belong to them. And so Greece is a strange country, and I told the story in a few words, in order to explain to you that it has characteristics which are unique. It is the only country of the European Union which does not have feudal past, where the institutions are not the long evolution of feudal institutions into modern institutions. It is a state which was created artificially on a piece of land, which we liberated in 1830 and later in the other wars, and which we implanted, the institutions of Western Europe from scratch. Nothing to do with the Ottoman past. That's why when I teach my students, I always tell them, but if you want to understand the history and the spirit of the Greek public institutions, you go back up to 1821, and then you have to take the plane to go to Paris or to London in order to understand the spirit of the institutions which were implanted on Greek soil. And we are very proud of that. So this is the story. And this is the first part of my intervention. The second part, the constitutional values. In 1821 we made the revolution, and in 1822 we had already, despite not liberated yet the country, we had already our first constitution. And this constitution was in the line of the French revolutionary constitutions, and the principle of equality as well as the principle of social justice were very well rooted in that constitution. And you will find those principles very well rooted, anchored in the Greek constitutions ever since. Greeks are crazy about equality and are crazy about social justice. This is why the political battles in Greece very often take very strange shape, because we are always ready to fight for that, sometimes forgetting that we destroy our country through the fight for equality or for social justice. This country which was created had always weak institutions. Why? Number one, because those institutions, as I said, did not come out of the spirit of the people, they were implanted. They came from elsewhere, and they had to be absorbed. Secondly, because every time we had organized the public powers, we had wars in order to expand the country. So we had, at the end of the war, we had to recreate the institutions. And this went up, especially up to 1922, when we lost the wars for the Aegean part of the Asia Minor, and 1 million and a half of Greeks fled to what is Greece today. Another million were lost in very strange circumstances, which there's no need to remember now. We went twice in the First and the Second World War. In the Second World War, we were destroyed completely because we never surrendered to the Germans. We are the only nation, perhaps the smallest one, which never surrendered, and we were also in Normandy, but it costed. And then after we went out of the Second World War, we had a civil war, because we are very good in those things. And so the institutions have always been weak, and the public finances have always been weaker. If you borrow money, and I believe it's about 6 or 7 times we went bankrupt, silently or openly. I'm not trying to say that I'm proud of that. I'm trying to say that I'm proud that the Greeks, after all, created for ourselves a country. And I say that in Latvia, which shares, I'm sure, the same passion for their land. Now, we had a dictatorship from 67 to 40 to 74. And in 1975, we had a new constitution. This constitution involves a number of principles, which I'm going to bring to your attention in a moment. But I wanted to say that what the Constitution of 1975 brings is more or less the kind of state which was expanded on European soil after the Second World War. It was a statalistic constitution, a constitution where the state has a very active role into promoting society and economy. Now, what are the principles which are needed to be reminded here? The principle of equality of all, depending, of course, on their possibilities to contribute to the public use. This is Article 4, paragraph 5 of the Constitution. A very important principle in Greece, because, as I said, the Greeks are crazy about equality. The proportional equality, though, depending on their possibilities. Everyone must contribute depending on how much he can contribute. Article 2.1, the principle of respect to the human dignity. This is very important in the Greek society. We have very heroic moments in our history in order to preserve the human dignity, the individual's dignity, the nation's dignity. The principle of proportionality. The principle of proportionality was well developed by the Greek case law before it was shaped by the Germans. And you will find it in an extensive case law of the Greek Council of State. We have a Council of State which is a supreme administrative court. It has the name of the Conseil d'État, but it is only, almost only, a jurisdiction. And now the principle of constitutionality is provided for by the Constitution itself. Then in the Article 22.5, there is a very important statement that the state takes care of the social security of the people. It's the state which must provide social security through public bodies, says the Council of State in its case law. I mean that private social security is another thing. The Constitution says that the state needs to provide for social security itself, no matter what the people do with other contractual policies which they undertake. Then there is an Article 106, paragraph 1. Very important article, because it says that the state needs to program the economic development of the country, and the state needs to take all necessary measures in order to secure social peace. I mean, you don't find that often in the Western world articles like that, but it is essential, because this is an idea which is deeply shared in Greece by all political parties, and especially by the center-right winning parties, perhaps more than by the center-left political parties. Those are a number of principles which are useful for the development which will be made in a moment in my third part. But I need to add that the Greek courts do not only use as sources of their judgments, of their cases, the Greek-made institutional framework, but that they also need to refer to the international law, international sources of law. There is an article, the Article 28 of the Greek Constitution, which says that the international treaties which are ratified by Greece have superior force than the ordinary laws of the land. Below the Constitution, above the national legislation. So the Article 1 of the additional protocol of the European Court of Human Rights in respect to property has become very important in the times of crisis for the development of the case law of the case law for the constitutional values in times of crisis, which is what I'm talking about today. Now, how we came to crisis? We came to crisis because Greece joined the European Union in 1981, and this was the most important point in our history after the revolution, because it completed the mandate of the revolution to be with the civilized European nations to which we wanted to be together. And but at that point, we needed to reform the country, and we needed to reform it in a less statalistic way, because the international way of organizing the public powers and the relation between the public powers and the economy were changing, and the Greeks did not observe that. They, all the Greek political world was interested into finding solutions to the political problems coming from the past, from the Civil War, from the all sorts of divisions in the country, and they did not pay attention to the reforms. One of the reasons why they did not pay attention to the reforms was the euphoria which was brought by the European Union. Money was brought in Greece for the first time. That much money was coming to Greece. Things were, Greece changed. I remember Greece of barefoot people. And now you find highways, you find universities, you find Greece changed. But it was easy money, I mean to say. And the will for reform was even weaker because other things were going on. And then we joined the euro. Euro was an even bigger achievement of this Greece, which, as I said, exists by coincidence, and because that was the dream of a nation for centuries. And they say that we came into Europe because we lied. This is not true. Believe me, this is not true. Brussels knew everything that we did in order to comply with their requirements, and they helped Greece to do it. And everybody was happy because we were joining in, and everybody knew that the way we went in perhaps could not be satisfactory if we were not helped by Brussels to do it. This is the truth. This does not, of course, it's not an excuse for the Greeks, because it's our country and we have to look for our country. But it is my opportunity to tell you, because I am talking to an important nation which is geographically far from us, and perhaps you need to know the truth. Whatever the truth is, the euro needed reforms. I direct an institution which is called the European Public Law Organization. It is created by international treaty, and 16 countries have already ratified the treaty and are members of it. And I remember that when the euro was introduced, we invited the then president of the center-right party of Portugal to give a lecture. This man is now very well known because he is the president of Portugal, Professor Marcelo Rebelo de Sousa. I remember, and this is published in our publication, the European Review of Public Law. He ended his lecture by saying, remember, the euro wants reforms. If you don't do the reforms, you are going to regret that you went into Europe. We did not regret that we went into Europe because we went into Europe for political reasons. We wanted, and we want to be the heart of Europe. We want to be the heart of Europe not only in cultural terms, we are Greeks, but we want to be in the Europe in honorable terms at all points and at all points of view, at all levels. But we forgot that Europe needed reforms, as did many others, but I'm talking of us. So we came into crisis. We had an extended now case law, and I come to my third point about how what is happening in Greece conforms or not with the constitutional values. This case law starts in 1912 because it needed time. The crisis started in 1910. It needed time for the Council of State, and most of it is case law of the Council of State, to give answers. So, at one point, they cut the salaries of the civil servants. And the civil servants went to the Council of State. The Council of State said in a very first decision that when a country, Greece, is in a crucial condition and reforms are needed, and the reforms demand a new consideration of the expenses, of the public expenses, and the country is in danger unless they do cuts, then those cuts have no constitutional problem, and they do not contradict the principle of equality because they are cuts for everyone, and they do not contradict the principle of the human dignity because the public interest of saving the country comes first. This is the first time ever that the Council of State, the Supreme Administrative Court of the land, put into the parameters.
Dear Speaker, I'm extremely sorry to cut your speech a little bit, otherwise we would like to have to skip some other reports.
Good. Do you give me 2 minutes?
Yes, of course.
Good. Start counting. And they said it is the first time that the parameter of the public interest for saving the economy of the country comes into this case law. Then they cut the pensions. They have cut the pensions in Greece 15 times. And the Council of State said again that this is not against the human dignity. Then they cut the salaries of the judges, the people working in the public order, and the law professors. There, the Council of State said that the cuts were unconstitutional because those are specific parts of the public interest, and if you don't have judges, people working in the public order and working as professors, because we have a special constitutional provision for professors, then we don't have a state. As for the privatizations, they said that they are constitutionally okay on the condition that there will be water running in our houses, and water running in our houses without, but not on profitable terms for the company. I completed my intervention, so I kept my promise to the President. The important, as a conclusion, to remember is that the Council of State decided that those changes in the life of the Greeks were not affecting the human dignity principle. I wonder for how long this is going to be like that. Thank you so much.
Frank Šāpe, Freiburgas Universitātes profesors, eksperts saistību tiesību, apdrošināšanas tiesību jautājumos, kā arī tiesību vēstures jautājumos. Daudzu grāmatu un citu publikāciju autors.
Dear Dean, dear Justices, dear colleagues, it is a great honor for me to deliver a speech about human dignity in front of such a select audience. And we have heard now a lot about human dignity. For the German federal constitution and the German legal practice, the concept of human dignity seems to be some kind of deus ex machina. Whenever statutory law and whenever constitutional basic rights fail to achieve the favored result, human dignity in Article 1, Section 1 of our federal constitution, the so-called basic law, fills the gap and jumps in to justify any verdict. The same is true for German politics. Whenever Federal Chancellor Angela Merkel tried to justify her immigration policy and the distribution of refugees around the European Union in late 2015 and early 2016 against reservations in the rest of Europe, especially Eastern Europe, she relied on human dignity. Very much on the contrary, the aim of this speech is to challenge the German mainstream view on human dignity in order to preserve the right balance between our lawmaker, the federal parliament on one side, and the judiciary on the other side. And as you will see explicitly, I'm not a member of the distinguished Freiburg School of Public Law. I speak here as a legal historian and a liberal civilian lawyer. Why is human dignity some kind of magic wand in Germany? One cannot blame the federal constitution itself for any pathetic or quasi-religious gesture. Look here at the simple wording of our constitution. Few words and a big result. The official English translation of Article 1, Section 1 simply reads as follows: human dignity shall be inviolable. To respect and to protect it shall be the duty of all state authority. The wording and system of the two sentences reveal some fundamental decisions about human dignity, but other very important points are left open. Sentence 1, as we can see, lays down that human dignity has a special status. I don't say a principal status or a paramount status, but a special status. Since human dignity stands in front of the following basic rights of our Constitution and in front of all other provisions, it is also clear that human dignity itself is no basic right, but stands somehow beside all other constitutional provisions. I also don't say it has a paramount status here. Therefore, the provision in Article 79 of our Constitution, the so-called eternity guarantee, to modify Article 1 of our Constitution has insofar only a descriptive function. Sentence 2 on the board partially enlarges the protective range of human dignity. The word respect repeats the prohibition in sentence 1, but the word protect goes beyond sentence 1 and establishes the public duty for active protection of human dignity. Other aspects of human dignity are unrevealed here on the board. So, for example, the question, what is a philosophical foundation of human dignity? Or what is a normative substance? Is it some superior right, a binding rule? Or is it maybe only some non-binding program? It is also an open question if we can derive here from human dignity any specific right for performance of social duties, for example, the payment of unemployment money. Let us turn now to the historical dimension. The roots of human dignity in the federal constitution go back to ancient times and to Bible. But in my opinion, they don't contribute much to enlighten the missing pieces of our constitution. In classical antiquity, Cicero spoke about human dignity in the context of his fight against hedonism. Some scholars try to justify or to interpret Cicero in a way that he is a founder of our present understanding of human dignity. I disagree. In my opinion, the ancient society was about hierarchy and not about equality. The true foundation of human dignity lies many centuries later in the Renaissance, when Giovanni Pico della Mirandola abandoned the concept that mankind mirrors God and returned to humanity's unique nature. Immanuel Kant, nearly a Baltic philosopher, provided a further milestone in the age of enlightenment. Kant shaped the formula that no man shall use another man as a mere tool. The constitution movement of the 19th and 20th century in Germany adopted human dignity very late. Attention shifted to human dignity when the resistance against National Socialism, you see here, drafted plans for a post-war order for Germany. It is not an exaggeration to say that the atrocities committed by the Nazi regime assisted in the birth of human dignity as the frontrunner in our constitution. In other words, the historical foundation of human dignity in our constitution is very short time and, in my opinion, not very firm. From a comparative perspective, human dignity is no singularity of the German federal constitution, as we all know, but it has very different scopes of application. So the specific German concept of human dignity is not some kind of natural law given by God, but only one possibility amongst many other possibilities. So indeed, as we can see here, the overwhelming majority of the member states of the European Union rely and implement human dignity, also European law, and for example also Switzerland or the Universal Declaration of Human Rights. But however, it is very important to stress that the normative dimension of human dignity varies substantially within Europe and abroad. So, and some countries like Greece even use human dignity in multiple approaches. So I identify 4 different approaches. The first approach moved the concept onto the programmatic or even metaphysical level, which speaks more to politicians and to the public than to judges. In Czechia, human dignity represents the constitutional spirit. In Greece, it is a fundamental public duty. In Bulgaria, the highest principle, and so on. Other constitutions write down a constitutional mandate to secure human dignity beside freedom and other values, but without any detailed description how to transform it into concrete legislation. The second approach implements human dignity in different intensity as an applicable and binding basic right. The Polish constitution, for example, grants human dignity the status as a source of all rights and every freedom, whereas most German federal states, the Bundesländer, and outside Germany, Hungary, the Charter of Fundamental Rights, and to a lesser extent Switzerland, follow the German federal model, as we have seen on the board. A less ambitious approach reduces human dignity to a basic right of personality or just to equality. You also spoke about equality before. Human dignity is also utilized as a protection against public infringements of basic rights. Finland, Greece, and also the Baltic states specifically use human dignity as a supplement to the prohibition of death penalty and torture, as you know. The third approach to human dignity uses it to limit the private sector, for example, the Weimar Constitution, or as I have read, in Greece. The fourth and last approach defines human dignity as a social right or social boundary for working conditions, for example, in Belgium. What is now the right concept, the content of human dignity at all, despite all relativity in Europe? Kant laid the foundation for a rational concept of human dignity, which is still the right approach today. Kant observed that one cannot verify the transcendental reality outside your own mind, but you have to rely on the logical form of the mind called reason or good sense. The consequences of Kant's philosophy for human dignity are threefold. First, human dignity must not appeal to God, social values or equity on the terminological level, but to human reasoning itself. Second, the concept of human dignity demands a rational application in its legal environment. It must submit itself to the ordinary methodological standards as all other sentences in our constitution. And third and last, the inner morality of human dignity consists in Kant's categorical imperative that nobody should be used as a mere tool for another person's purpose. If we follow the traditional German approach, human dignity in Article 1 of our Constitution influences legal application in two ways. First, it is at least a basic right or even a superior right above all other basic rights. Second, human dignity is used to interpret the basic rights in Article 2 to 19 and all other provisions, even statutory provisions in our legal system. In my opinion, the first thesis misconceives the position of Article 1 in the constitutional system. Since human rights and specific German basic rights are only mentioned in subsequent sections of Article 1, in my opinion, human dignity in the first section of Article 1 is neither a superior right, neither a simple right, and also no basic right. It is no right at all. Although Article 1, Section 1 implements a duty to protect human dignity at a first glance, the words duty and pay attention do not establish a normative binding rule at all. Consequently, the second thesis is also a bit mistaken. It underestimates the constitutional content of the basic rights. The abolition of torture, for example, very important indeed, is already included in Article 2, Section 2 of our Federal Constitution, which protects life and health. Since Article 19, Section 2 of the Federal Constitution blocks any infringement of the essence of all basic rights, and thus torture is forbidden without relying on human dignity. The substantial core of a basic right is therefore independent from human dignity and needs no reference to it. The Federal Constitutional Court approved this narrow interpretation of Article 19 when it decided that the legislature could even completely abolish the right of asylum. This would not be possible if we interpret Article 19 in a way that it includes human dignity. You can see here on the board that here Article 1, and therefore human dignity cannot be abolished. And so we have to distinguish here Article 19, which is not under the eternal guarantee, and Article 2 is also not under the eternal guarantee, and here this basic provision, the eternal guarantee. These are two different topics. So I come now to my own approach. It is, as you see here, a very narrow path. Human dignity establishes a mere programmatic principle, in my opinion, an ethical foundation for the society and for the Constitution itself. In other words, human dignity is closer to the non-binding content of the preamble than to binding constitutional norms. Its scope of application is limited to the modest interpretation of other constitutional norms, like basic rights. Human dignity does not serve as an omnipotent argument during the process of interpretation, but as a last resort of rationality in the Kantian sense. Thus, human dignity is more like a test for plausibility than an independent argument. To protect the balance of power in our state, human dignity must shrink to a narrow Kantian definition as inherent autonomy of human beings. So, only in this narrow sense, human dignity shall survive or can be applied in our constitution. And in this very narrow sense, I must say it has an absolute value. So in my opinion, I don't want to advocate torture and other modern developments, just to the opposite. Human dignity applied properly can be here a rational argument of last resort if other constitutional provisions are at a first glance not applied properly. I come now to two examples for the non-application of human dignity. In public law, the judiciary refers to human dignity in cases like social law when the statutory law does not cover the preferred outcome. Article 1 of the Federal Constitution has become the door opener for transformation of the German legal system, where not the federal parliament but the Federal Constitutional Court sets the black letter rules for daily life. This is most obvious in the case of social law in Germany. It is a long-standing tradition of the Federal Constitutional Court to justify such a claim through a combination of human dignity and the principle of the social welfare state. The court asserts the legislator must guarantee a subsistence minimum that is in line with human dignity. The same line of argument is also used, for example, in our law of taxation. Human dignity itself, not statutory law, is said to be the basis for the claim in social law, whereas the principle of the social welfare state demands that the legislator must enact detailed provisions. The result is not a limited but a universal entitlement, because the Federal Constitutional Court wants to grant social benefits irrespective of nationality. Subsequent to the decisions of the Federal Constitutional Court, the Federal Social Court ruled that every citizen of the European Union who lives in Germany can claim welfare payment. In essence, the Federal Social Court circumvented the decision of the European Court of Justice before, which denied unemployment benefit, the famous Hartz IV, to European citizens under certain conditions. This extensive application of human dignity, in my opinion, misjudges the normative scope of human dignity. The very wide application also destroys the established balance between judiciary and parliament. There is no case where human dignity could demand concrete administrative or legislative actions. That is not true only for the social welfare state, but also for other areas like immigration. In private law, human dignity has also little room for application under the umbrella of the classical liberal model. The principle of autonomy, which is part of the basic right of the general freedom to act in Article 2 of our Constitution, replaces human dignity, in my opinion, in private law, acting as an overarching fundamental principle for more specific rights, for example, for the freedom of contract. Now, my short conclusions. The German mainstream view grants human dignity in Article 1 of the Federal Constitution the status of a key principle of German constitutional law. Human dignity acts as replacement for other parts of the Constitution and all statutory law. However, this understanding of human dignity exposes our legal system to enormous risks, since human dignity is used as some kind of magic wand to override every statutory decision of our parliament. In order to prevent human dignity from dilution, so I say, I don't want to abolish human dignity, but I would like to prevent it from dilution as a daily and equitable remedy to correct unsound decisions. The concept of human dignity demands a new and very narrow understanding, which prevents the most harmful public intervention into the private sphere. For example, prevents torture as a plausibility test. On the other side, the traditional very wide scope of human dignity should be abandoned. For example, human dignity does not command, in my opinion, any unlimited access for immigrants to the German social welfare system, and it also does not grant any specific welfare entitlement. Human dignity also lacks the quality of a right at all. It is a mere reminder of last resort. However, so don't be shocked about my liberal approach. This conclusion shall not serve any argument against the German social welfare state, and also not about immigration in Germany, but simply as a warning that the decision shall lie in the hand of the parliament and not in the hand of an omnipotent judiciary. Thank you very much for your attention.
Nākamais runātājs Mārtiņš Paparinskas, University College London lektors, daudzu rakstu autors, arī izdevēju kolektīvu dalībnieks.
Cienītā dekāns kundze, godātais Latvijas Universitātes priekšsēdētāji, godājumie tiesneši profesori, esmu ārkārtīgi pagodināts par iespēju uzaicinājumu uzstāties alma mater. The topic of my presentation today is constitutional values in contemporary international law. I must say that when I proposed the topic about half a year ago, I didn't quite appreciate how prescient my skepticism about the role was proved to be at succeeding events. But nevertheless, there are 4 points that I would like to address, and I would like to perhaps subvert the usual approach to reasoning that draws upon a great suggestion from Alice in Wonderland that when one talks, one starts in the beginning, then continues until the very end, and then one stops. I would rather like to start at the end, providing a snapshot of some current issues that international law is dealing with, in a rather brief manner, then step back and provide what seems to be the traditional view of international law, with its considerable emphasis on private law analogies, seeing very little public in the technical sense in public international law. In the third part, I will look in greater detail at 3 selected case studies that are often suggested as such that show greater publicness, greater constitutionalism in contemporary international law. And finally, so perhaps leaving mysterious my own final views, I will consider whether there is still a role for a skeptical view. So what does international law do at the moment? What is the international legal order concerned with? Our critical colleagues, I suppose, have taught us that even an objective and impartial answer might not be the full story, because it depends what we are asking, and more importantly, what we are not asking. Now, plainly, one could have considered case law of some international courts, perhaps practice of some international organizations. In a moderately arbitrary manner, I instead looked at the recent report of the International Law Commission. As some of you will know and others may recall, the International Law Commission is a subsidiary organ of the United Nations General Assembly, created in the late 1940s to engage in progressive development and codification of international law. And the practice is such that it is not unreasonable to consider topics as a fair reflection of things that international organizations, states, and academics are concerned about at the moment. So what is International Law Commission dealing with? Now, if we look at the project that it has concluded, we see that first there's a number of hugely important topics for technical international lawyers. Under the guardianship of Sir Michael Wood, the International Law Commission has concluded its work on identification of customary international law, plainly a hugely important issue for those who advise governments or who practice before international courts. Georg Nolte similarly has concluded his work on treaty interpretation, and perhaps point of somewhat surprising importance, the issue of provisional application that we have heard quite a lot in the last few weeks in the context of CETA. But these are not points of particular public character. These are issues of lawyers' law that have perhaps even particularly private implications. But at the same time, if we look at other topics, there is a lot that seems to carry a certain constitutional significance. We see its consideration of environmental law, human rights law, humanitarian law, international criminal law. Indeed, the International Law Commission has even started its work on that most constitutional manifestations of international legal order use Kogen's peremptory rules of public international law, those few and elusive concepts from which states, or so it is suggested, cannot contract out. So if we look at this snapshot, it does seem that there is quite a lot of constitutional character going on in international law at the moment. How does that fit in with the background of international law? Well, the standard reading of the international legal order, I think, is the one suggested quite a long time ago by Sir Lauterpacht, perhaps one of the greatest international lawyers of last century, born in a small village called Zvolky, a few kilometers to the north of Lvov, and finished his life as a Huel professor of international law at the University of Cambridge and judge at the International Court of Justice. And Sir Fisher's argument, I think in line with a lot of our basic intuition about the way how international legal order operates, is that it is most easily analogizable to private law. States are like individuals, organizations are like corporations, legal relationship and responsibility at the international level is analogizable to the same regimes at the domestic level. So very bilateralizable conception, rather a bundle of many private relationships, even if sometimes expressed in multilateral form, than something genuinely multilateral. The standard benchmark for determining whether the legal order is more on the private or more on the public side is whether bystanders can take a legal interest in a particular relationship between two parties. Now, if I pick entirely accidentally and perhaps a little bit unfairly on my good old friend Dr. Jānis Plebs, and imagine that we are both conceive of ourselves as states. If I were to go up to Dr. Plebs and take away his watch, that would certainly create a certain type of legal relationships between us. Presumably there would be legal interest on behalf of Dr. Plebs to insist that I seize this unlawful conduct, compensate or provide restitution. He could take certain measures, perhaps take me to courts, apply countermeasures, go to international organizations, and I would have corresponding obligations to provide this restitution, bond, and so on. But the benchmark for publicness is whether you, as other states and international organizations, would have a legal interest here. If I have taken this watch, would you have an obligation of non-recognition of this transfer of title? Would you be entitled to step in and somehow assist Dr. Plebs? And traditional international law would say that you shouldn't. International law is just a conglomeration of various bilateral relationships, and this is this statement that comes out in perhaps one of the most criticized judgments of the International Court of Justice, when Liberia brought a case against South Africa in relation to apartheid and unlawful territorial control, and the International Court of Justice said that you do not have a legal interest in this game. This is a purely bilateral matter, you have not been affected, that's really, you have no skin in this game, and international law does not recognize you. So something supremely private law-based. It is sometimes suggested that we have moved on beyond Southwest Africa. So I want to test that proposition against the benchmark of three areas. So essentially, the first one builds on Southwest Africa. Is Southwest Africa still good law? If another state wanted to insist, wanted bring a claim, wanted to complain, would international law call this right? Secondly, even more importantly, if you wanted to step in and do something about it, perhaps apply sanction, perhaps take away my own watch. I don't have a watch, so it's not a perfect example, but perhaps take my iPad or something of the sort. Is that something that international law permits? And thirdly, are we now living in an age of adjudication? It's classically, I think, thought that international law is a tad on the primitive side because we do not have compulsory international jurisdiction. So let's start here in the beginning. The starting point is provided by the 2001 International Law Commission's articles on state responsibility, concluded under the authorship of great Judge James Crawford, perhaps one of the greatest international lawyers of our time. That provides in Article 48 seemingly that it is possible for bystanders, non-injured states, to use the technical parlance of international law, to bring claims in such situations. However, at the same time, it was acknowledged in the International Law Commission that this was perhaps more a case of progressive development than statement of the law, or in other words, something that might provide a framework for states to engage in practice and develop the law in that direction, but if a court had to decide that issue in 2001, it would not necessarily say that that is already good law. So it stayed for a number of years, and in the last 4 years, quite some appropriate symmetry, we have had 3 cases that have dealt with this issue and that have sometimes thought as reflecting the greater constitutionalization and multilateralism. And I would suggest that if we look a little bit closer, there's a greater deal of ground for skepticism that one might assume. The first case was decided 4 years ago. It was a case brought by Belgium against Senegal in relation to failure by Senegal to either extradite or prosecute Hissène Habré, the former head of state of Chad, accused of grave international crimes. And the dichotomy between extradition and prosecution is a standard way how international criminal cooperation treaties deal with this. Now, the crucial question in this case is, what is the interest of Belgium? Hissène Habré is not a national of Belgium, alleged crimes did not take place in Belgium, and even though Belgium was speaking about suffering by its nationals, it really was not a very strong point. The International Court of Justice importantly recognized that Belgium had a legal interest because the Convention Against Torture was there for the protection of a collective interest common to the parties. So essentially, Article 48, 1A. At the same time, we dig a little bit beneath the surface, there is much less consensus on the international court that might suggest. It is usually a good sense to, I suppose, to get the pulse of international legal order, to read the separate opinions by the judges nominated by certain of the great powers. Plainly, they are independent and impartial, plainly they speak on their own behalf, but still there may be certain echoes of their thinking. And if we read the separate opinions of judges nominated by China and Russia, we see considerable skepticism about this multilateral approach. And if we read the separate opinion by Judge Donoghue, the United States judge, she accepts it, but in a considerably more conservative manner. So here we already see the wrinkles on the march of multilateralism. The second case was decided 2 years ago, a case brought by Australia against Japan regarding alleged breach of obligations under the Whaling Convention regarding catching of whales in the Southern Pacific. And clearly here we have the same question. What is the legal interest of Australia? They are not Australian whales in any loose sense. These are things that take place on the high seas. Why can Australia bring the claim? Again, the case proceeds. Japan loses by an overwhelming margin, but the court does not address and explain what the legal interest is, suggesting, perhaps for good tactical reasons, everybody was happy to let it slide, but still that is far from a unanimous endorsement. Finally, I think wonderfully for pedagogical reasons, just a few weeks ago, the International Court of Justice hands down the third case in the same line of thinking, a case brought by Marshall Islands against a number of nuclear weapon holding states regarding nuclear non-proliferation. Classic question, What is the legal interest? The court dismisses the case on other grounds, but I think it's interesting to see the contrast between opinions by Judge Crawford, now a judge on the International Court of Justice, very strongly taking the view that multilateral interest exists, and the Chinese judge who suggesting that these are things that we might want to come back at some point, but we are clearly not there. So this, it seems to me, is at the very least a mixed picture. Let us go perhaps closer to real life and enforcement of multilateralism. What are the options for third states to engage if a certain state has acted in breach of public international law? I guess I suppose in our regional setting we would most naturally think about the annexation of Crimea, considered by most people and states to be an example of that. What is it that bystanders can do? Now, plainly, Ukraine can do quite a lot, and plainly, Security Council could do quite a lot if it wasn't vetoed. But what is it that bystanders can do? Well, if use of force was involved, perhaps they could engage in collective self-defense. They could also do things that are unfriendly, but not unlawful. For example, there's usually no international obligation to provide visas, so refusal of visas would be unfriendly but not unlawful. But what if states want to go further? What if they want to act in breach of certain international obligations to nudge the compliance? Now, just be very careful, I'm not suggesting that United States and European Union sanctions are in breach of international obligations, but if they were, would that be something that international law would permit? And here we have a mixed position. On the one hand, the International Law Commission's draft itself seems to leave the question open, and we know that in the practice of negotiation, James Crawford thought that such a right did exist. Many states thought that it did not exist. So Article 54 that you have at the top of the page leaves the issue open. There is considerable support that such a right exists, and plainly United States and European Union take that view. Questions about sanctions are questions of political expediency. There is no grand debate whether there is legal interest in adopting particular measures. But there's also an opposite view, and the sovereign equality of states. The practice of states such as Russia and China does carry considerable weight. And this June, the declaration adopted by these two countries expresses considerable uncertainty about the existence of such a right. Now, is this a question that is likely to be settled this way or that way? It seems to me that it's very unlikely for the way how reasons how the trade law and human rights law, investment law is structured. But that perhaps brings out the point that international legal order can tolerate a considerable degree of uncertainty even regarding such constitutional issues, points on which a considerable part of international community is proceeding as if they were certain and others being much more skeptical. My third point relates to international courts. International lawyers are traditionally quite defensive when it comes to international courts. In domestic law, we are told they can do almost everything. In international law, we always have to demonstrate the additional consent. In international law, we have, as Sir Chris Greenwood, the UK judge of the International Court of Justice recently suggested, been living in an age of adjudication. Old courts that were almost moribund have been reborn since 1990s. Permanent court of arbitration in particular, new courts have started operating, and on many crucial politically significant issues we are going to courts rather than political settlement. Again, if we look at Ukraine, Ukraine has taken advantage of a whole spread of international legal instruments to rely on. It has sued Russia in the European Court of Human Rights. Individual Ukrainians have gone the same way. Individual Ukrainian investors have done the permanent court of arbitration with their claims. There is a just launched claim in the International Tribunal of the Sea for provisional measures and Annex 7 Tribunal for delimitation. And we just heard a few days ago that the International Criminal Court has identified an international armed conflict between Russia and Ukraine. So quite a lot going on. At the same time, we also see a sort of a backlash against courts. And I guess that in various instances, you might think that that is specific to some courts. Investment arbitration perhaps is peculiar for certain reasons, human rights for others, international criminal court for yet others. But it seems to me that we are getting somewhere where there is a consistent backlash and questioning of exercise of international judicial authority. So where do we get? I would like to read briefly 3 notes from 3 states, and I think I might have to ask for 1.5 additional minutes. The briefest 1.5 minute possible. It is traditional for the United Nations General Assembly to consider comment on the ILC's work in the 6th Committee, and they just did it 2 weeks ago, and particularly in the question of peremptory rules. It's often useful to see what the great powers say. This is what France said, and I think it's worth saying it in the original, just to reflect the bitter contempt that this conveys. Il paraît plus approprié que dans un premier temps, le rapporteur spécial, la Commission se concentre sur l'examen des pratiques et des opinions suivant les versions des États au sujet de jurisprudence. Faute de quoi, la Commission risque de s'engager dans une approche excessivement théorique, voire idéologique de cette notion. United States said the following thing: we are concerned that the meaning and purpose of the Commission's work is unclear, and that describing use Cogen's norms as protecting quote-unquote fundamental values and as quote-unquote universally applicable would open the door to attempts to derive use Cogen's norms from vague and contestable natural law principles without regard their actual acceptance and recognition by states. And this is what China said. Elements of use Cogens have a bearing on the major interests of all states and direct implication on their rights, obligations, and responsibilities. Is there a need for adding new core elements? What is the basis for such additions? What applications would they have? These are questions that China suggests warrant further studies. So at the very least, we have a hugely mixed sense of what states think about it. Where does that leave us? And I must say I was quite struggling of where that might leave us. So it might leave us in the sense that the James Crawford quote that I have provided gives us, that this is a business as usual. This is how international law works, through assertion, reassertion, and confirmation. Could also be, and I suppose to some extent, the sense that we are no longer in an inexorable march towards greater integration, internationalization, institutionalization. Perhaps on some points we have to keep an open mind whether that is the direction of the system. And I think in some ways it's morally a stronger position to take. We are being internationalists not because that is a role in history. We choose to do so. But the final point, we heard quite a lot about the Greek constitution. It reminds me of what a great friend of mine says, and I'm not a Greek constitutional lawyer, so perhaps I have entirely misunderstood his point, but in his view, it always praises the last provision of the Greek constitution, which suggests, again in his description, that the existence of Greece rests in the final analysis in the hearts and patriotism of the Greek people. That sounds like a great proposition to me. Whether we are thinking of dense policies like national states in the European Union or much thinner policies, or other polities than international legal law, it's fundamentally our own responsibility to advance constitutional values. Thank you.
Paldies Markiem Paparinskim. Mums plānotās diskusijas brīdī ir smaga alternatīva. Mums tātad pusdienas mēs nedrīkstam atlikt. Nevezerēs. Varbūt viens jautājums. Es saprotu, ka tas bija ļoti svarīgs no auditorijas vienam no runātājiem, bet lūdzu lietot mikrofonu un atbildēt ļoti īsi arī.
Thank you very much. I had a question to Professor Viswal. I think that this question might be of general interest, that's why I'm asking this here. I found this enhanced method most interesting, but I would like to ask you, perhaps you could get more concrete. What policies do you have in mind? Perhaps some examples. And could it be backdoor for European Army?
European Army?
Please use the mic.
Well, that's not first policy domain, so where I'm thinking. And by the way, with regard to flexibility and differentiation, there is a reference in the Treaty on European Union to cooperation with limited groups of member states in the domain of defense. So that's outside the scope I'm referring at. I'm referring at the traditional, the former EEC, European Economic Community domains of cooperation. And, well, obviously, you can look at it from different angles and different perspectives. However, as I've explained, I mean, we have arrived at a stage of cooperation where we have to make new choices, and we have to reflect about this issue. When we started, because the Netherlands is the founding father of the European Union, we were with 6 not like-minded countries, but they shared a lot of values, etc., etc. And since then, obviously, the integration process has gone forward, touching upon the fundamentals of national society. So just as home affairs, whether it is asylum, even visa policy, or criminal law, police code, it touches upon the fundamentals. And apparently, we have arrived at a certain stage of cooperation where not all member states anymore are willing to make this adventure possible. And that's why on the one hand I want to protect the interests of the EU. I'm always trying to also to defend the interests of the European Union as a whole. The whole range of objectives which have been subscribed to by all the member states, mind you, all the member states, and those who are in fact the coalition of the willing. So defense is outside in a way, however, it is already integrated in the treaty with regard to coalitions of the willing, as you may know. But I'm referring at the ordinance, so the new domains which we are now entering in and really touching upon the fundamental issues. I respect those member states who indeed do not want to make further steps forward. And in the end, my assumption is, but of course 20 minutes is not really an appropriate space of time to explain this fully. My idea of membership has to be a little bit scaled down. So for example, with regard to the United Kingdom, I hope in the end that we can keep them in by respecting a kind of minimal level of values, principles and policies, which by the way should include the internal market and certain dimensions of the area of freedom, security, justice. In that respect, the UK has already a problem because, as I explained, they are outside the area of freedom, security, justice. So it's complicated, but I think necessarily we have to reflect about these issues. So I appreciate your question, but more particularly, the defense area is not the right example for me. Although I respect that in view of the fact that not all member states are NATO member, this certainly also lends itself for a form of flexible cooperation. I hope that will do.
Another question? Some comment or question?
On this.
Yes, thank you.
Well, speaking of brigade, I respect what you just said, but I believe that this is now the heart of the problem of the European Union. I certainly believe that the European Union, when it started, it was the European, whatever it was the name of those days, it was a European Union of 6 countries. And they were happily married among themselves because they lived together for centuries. they knew each other, they shared the same values. Eventually they had wars between France and Germany, so they could do with one act two things. Number one, end the wars. France was happy because they were thinking that they had the first, that they won the war and the others were defeated. And so the conditions were ready to come back to the old empire of Charlemagne practically. Well, I believe that we are very, very fortunate that today we are 28, still 28, because Brexit never happened up to today. And I believe that the Europeans of the six must understand that they are not the only Europeans, that the other 22 are equally Europeans. Very often the other 22, and especially the 10 newcomers, try to tell us something. Perhaps they are wrong in what they are trying to say. But they tell us something, and no one listens to them. Instead of saying, let us go back to the Europe of six, and let the others do whatever they want, join or not join to what we are, let us talk to each other, because it is in our interest to understand each other. Today I'm one Greek who is in Latvia. Tomorrow a Latvian comes to Greece. How many times a Latvian and a Greek meet have met in the last 2,000 years? Very, very rare. But now we are in the same family. And instead of finding the way out for someone, it is better to talk, to understand each other, and rebuild Europe. The discussion over Brexit is the opportunity. How come we can have a Europe without the winners of the Second World War? This I cannot understand. I mean, we should not even think of that. Thank you.
Mr. Chairman, I can keep it very short. Everybody has deserved his lunchtime. You should not misinterpret what I'm saying. I do not want to dismantle membership of the EU. I do not want to force countries to get out. On the contrary, I want to keep intact the group of 28. I'm looking for options, flexibility options, even to safeguard the United Kingdom as a member. However, my only my only plea is to look for options for those who want to go forward. As I have explained already by now, whereas all 28 have subscribed to the objectives of the EU, as have been embedded in the European Union treaties, we simply have to observe that not all of them want to cooperate in the process to implement these objectives. That's one thing. With regard to the future, and that's indeed the future agenda of the EU, indeed, I do not want to dismantle membership. I only want to create options for those who want to advance. And it's my hope and expectation, as I said in my last sentence, that Latvia is one of them, and Greece, by the way, also. But there are certain countries, for political reasons, because of populism, because of Euroscepticism, have not that will, which is fine. We should respect that. Nobody should be bound to make further steps. However, the groups of the willing who want to do so, should be facilitated to do that. And apart from that, it's indeed a rather fundamental approach. It requires much more time. However, luncheon is also important.
Paldies visiem konferences dalībniekiem. Līdz ar to konferences šī pirmā sesija slēgta.
godātie tiesneši, profesori, klātesošie, darbie un mīļie studenti. 2016. gads neapšaubām ir Satversmes tiesas gads. Šogad mēs svinam 20 gadus kopš spēkā stājās grozījumu Satversmē, kas lika konstitucionālu pamatu Satversmes tiesai. Šodien mēs svinam 20 gadi kopš stājies spēkā Satversmes tiesas likums, un 20 gadi decembrī, kā tas tradicionāli mums ierasts Satversmes tiesā, mēs svinēsim īsto Satversmes tiesas dzimšanas dienu. Un, starp citu, šis gads ir arī mana mīļākā pētniecības institūta konstitucionālās sūdzības 15 gadus gads. Satversmes tiesas loma un nozīme ir analizēta rakstos, grāmatās. Par to ir daudz runāts konferencēs un semināros. Un šķiet, ka katram juristam Latvijā ir savs viedoklis par Satversmes tiesu. Un tas ir tādēļ, ka Satversmes tiesa tik daudz var ietekmēt, tik daudz dzīvi var ietekmēt, tik daudz norišu var ietekmēt, pateicoties Satversmes tiesas nolēmumu juridiskajai dabai. Šodienas sekcijas sēde ir veltīta Satversmes tiesai. Es ļoti priecājos pirmkārt vadīt šo sekciju, otrkārt es esmu lepna un priecīga par to, ka mums ir pagodinājuši Satversmes tiesas priekšsēdētāji, bijušais priekšsēdētājs profesors Enziņš ar savu klātbūtni un arī esošais Satversmes tiesas priekšsēdētājs Laviņkungs ar savu klātbūtni. Un, protams, es priecājos un jūtos pagodināti, ka pie mums varēja ierasties arī Lietuvas konstitucionālās tiesas priekšsēdētājs profesors Žalvis. Un, protams, priecājos redzēt jūs visus šeit. Pirmais runātājs mūsu šīs dienas sekcijā ir profesors Aizvars Enziņš. Un kurš gan cits, ja ne viņš? Jo viņš ir bijis pirmais Satversmes tiesas priekšsēdētājs, kuram vislabāk ir zināms, ko nozīmē izveidot Satversmes tiesu. Kā tika vērtēts tās darbs sākotnējā darbības posmā, ko nozīmēja nodrošināt Satversmes tiesas neatkarību. Profesors Enziņš ir arī Venēcijas komisijas demokrātija caur tiesībām loceklis, kurš aktīvi līdzdarbojas demokrātijas elementu stiprināšanā daudzās valstīs, tā skaitā profesors Enziņš strādā valsts prezidenta izveidotā tiesiskās vidas uzlabošanas komisijā. Profesors Enziņš šodien mums pastāstīs par to, kā tas bija. Un šī mums ir izcili reta privilēģija dzirdēt un redzēt un piedzīvot to, ko mums var pastāstīt cilvēks, kas pats to ir piedzīvojis. Jo profesora Enziņa referāts ir Satversmes tiesas pirmsākuma Latvijā. Lūdzu, Enziņa. Vēl, kolēģi, mums ir ļoti strikta darba kārtība, tādēļ es aicinu jums pieturēties pie atvēlētām 20 minūtēm, lai mums būtu laiks un vieta arī diskusijai, jo, kā jūs zinat, visi mūsu ārzemju viesi pulkstenis 3 dodas uz parlamentu, kur ir sarunāta tikšanās, kuru kavēt nevarētu nekādā gadījumā. Cerot uz jūsu sapratu, mēs arī esam gatavi klausīties visus referātus, tātad un referātu noslēgumā es aicināšu visus klātesošos izteikties un uzdot jautājumus, jo jums tāda būs. Lūdzu, profesori, vārds jums.
Paldies. Cienītā dekāna kundze, godājumais Satversmes tiesas priekšsēdētāja kungs, tiesneši, cienītās dāmas, godātie kungi. Man ir paties prieks, ka Universitātes Juridiskā fakultāte organizēt šo starptautiskā konferenci ir atradusi iespēju izveidot atsevišķu sekciju, kas ir veltīta Satversmes tiesas 20. gadadienu. Jāsaka tā, runājot par Satversmes tiesas pirmsākumiem Latvijā, pati ideja jau par nepieciešamību šādas institūcijas izveidēja būtībā nav jau. Ir jau vienīgais varbūt atgādināšu tikai to, ka par nepieciešamību veidot īpašu institūciju Satversmes aizsardzībai vēl 1920. gadā rakstā Latvijas Satversmes 8 gadi izteicās Saeimas deputāts Pauls Šīmanis, norādot, ka varu nodalīšana praktiski būtu nodrošināta tikai tad, ja mums būtu neatkarīga valsts tiesu palāta, kuru varētu pārbaudīt, vai parlamenta un izpildu orgānu lēmumi ir saskaņā ar satversmi un vajadzības gadījumā tos atcelt. Turpinot šo ideju, 1934. gada 8. maijā Saeimas deputāts Hermanis Štegmanis iesniedza priekšlikumu papildināt satversmi ar 86. pantu, kas paredzētu speciālas valsts tiesas izveidi, kuras uzdevums būtu pārbaudīt likumu, kā arī valsts prezidenta un ministru kabineta aktu atbilstību satversmē. Tomēr šāds priekšlikums Saeimas deputāta atbalstu neguva. Tie ir vispār zināmi fakti, kas ir publicēti arī gan satversmes komentāros, kas ir veltīta tiesu varai. Bet es gribētu vērst uzmanību uz to, ka vēlāk jau, varētu teikt, atmodas gada sākumā vēl LPSR, Latvijas padomes Sociāliskās republikas laikā, toreizējās augstākās padomes prezidijas izveidoja īpašu darba grupu juridiskās fakultātes docenta Sergeja Babājeva vadībā, kurai bija uzdots izstrādāt konstitucionālās tiesas likumu. Diemžēl kaut kur es nevarēju atrast savos arķīvos šo projektu kā tādu. Bet interesanti ir arī vēl kas, ka tai pašā LPSR laika posmā 1989. gada februārī toreiz Andrejs Krasliņš, advokāts, bija izstrādājis LPSR konstitūcijas jaunu redakciju, kur kaut kas bija ņemts no satversmes, jo paredzēja arī, kad ir tautas vēlēts prezidenta institūts, bet interesantākais ir tas, ka šajā viņa izstrādātajā LPSR konstitūcijas modelī bija arī nodaļa, 5. nodaļa, kas bija veltīta konstitucionālajai tiesai. Šajā nodaļā bija paredzēti 5 panti, un tie ir sekojoši. 77. pants bija paredzēts, ka konstitucionālajai ir pakļauti strīdi par likumu un likumdošanas aktu atbilstību konstitūcijai, strīdi par kompetenci starp dažādām valsts pārvaldes iestādēm, starp valsti un tās administratīvi teritoriālajām sastāvdaļām, apsūdzības krimināla noziegumos pret LPSR prezidentu, ministru padomes priekšsēdētāju un ministriem. 78. pants paredzēja, ka konstitucionālā tiesa sastāv no 15 locekļiem, no kuriem 1/3 ieceļ LPSR prezidents, 1/3 LPSR augstākā padome un 1/3 augstākā apelācijas tiesa. Un 79. pants. Konstitucionālās tiesas lēmumi tiek pieņemti vienbalsīgi. 80. pants. Konstitucionālās tiesas locekļi tiek iecelti no tiesnešu, Latvijas Universitātes Juridiskās fakultātes profesoru un docentu un advokātu vidus, kuriem ir vismaz 20 gadu ilgs juridiskā darba stāžs. Un 81. pants. Konstitucionālās tiesas locekļus ieceļ uz 7 gadiem, un tie nevar tikt iecelti atkārtot. Kā redzat, kaut kur kaut kas ir arī tas, kas ir šodienas satversmes tiesas likumā. Skaidrs, ka nekas tam līdzīgs izveidots tā laikā nebija. Un tālākā attīstība jau ir saistīta ar 1990. gada 4. maija augstākās padomas pieņemto deklarāciju par Latvijas neatkarību, kur tika 6. punktā noteikts, ka uzskatīt par iespējamu pārejas periodam piemērot Latvijas PSR konstitūcijas normas un citus likumdošanas aktus, kas šīs deklarācijas pieņemšanas brīdī darbojas Latvijas teritorijā, cik tālu tie nav pretrunā ar Latvijas Republikas Satversmes 1., 2., 3. un 6. pāntu. Un strīdus gadījumos jautājums par likumdošanas aktu piemērošanu izšķir Latvijas Republikas konstitucionālā tiesa. Bet tāpat laikā šāda tiesa izveidota nebija. Vēl jau vairāk atceraties, ka 1992. gada decembrī, kad augstākā padome pieņēma likumu par tiesu varu, tad konstitucionālās uzraudzības funkcijas tika paredzētas Latvijas Republikas augstākajā tiesā, kurā vajadzēja tikt izveidots īpašs departaments nekārtāts. Nekas tam līdzīgs nenotika, konkrēta soļa spērta šai virzienā nebija. Tad seko 93. gads, notiek 5. Saeimas vēlēšanas, 93. gada jūlijā tiek atjaunota satversme pilnā apjomā, tiek izveidots ministru kabinets, toreizējā ministru prezidenta personā darbojas Valdis Birkaus un tieslietu ministrs bija Egils Lētis. Un jaunā valdība, ministru kabinets, nāca pie atziņas, ņemot vērā starptautisko pieredzi, ka Latvijā būtu jāveido īpaša institūcija, proti satversmes tiesa, un valdība sāka strādāt pie likuma projekta izveidošanas un iesniedza attiecīgi 94. gada pavasarī gan likuma projektu par grozījumiem likumā par tiesu varu, no kuras attiecīgās normas, kas šo kompetenci paredzēja augstākajai tiesai izslēgt, kā arī par satversmes 85. panta izteikšanu jaunā redakcijā, kas paredzētu satversmes tiesas izveidošanu, kā arī pašu satversmes tiesas likuma projektu. 5. Saeima pie tā strādāja un faktiski nonāca līdz 3. galīgajam lasījumam, vēl 95. gada jūlija mēnesī, un, diemžēl, 96. gadā, tātad pēc neilga laika, bija paredzētas jau jaunas parlamentu vēlēšanas, 6. Saeimas vēlēšanas, un kaut arī satversmes grozījums, likums par tiesu varu, par satversmes tiesu bija pieņemts gan 1. gan 2. lasījumā. 3. lasījums jau sāka buksēt kādā veidā. Proti tādējādi, ka politiķi, acīm redzot, uzskatīja vai cerēja, ka aiz durvīm nav jaunas parlamentu vēlēšanas. Līdz ar to opozīcijā esošie politiskie spēki, acīm redzot, uzskatīja, ka vēlēšanās viņi iegūs labāku rezultātu un ka varēs veidot satversmes tiesu pēc sava ģīmeņa un līdzības. Jo būtībā kaut kur politiķiem virmoja ideja, ka satversmes tiesa tā būtu kaut kāds jauns politbirojs, kur attiecīgi tiktu dot norādījumi, kā pareizi vajadzētu izskatīt lietas, kā lemt un viss notiks. Līdz ar to, kad lieta nonāca līdz 3. lasījumam, Vispirms bija jāizdara grozījums satversmē, jo nebija jēgas pieņemt satversmes tiesas likumu, ja nav attiecīgi šī kompetence nostiprināta satversmē. Tad uz trešo lasējumu no 85 deputātiem, kuri bija klāt sēdē, reģistrējās tikai 63. Līdz ar to nebija attiecīgi kvoruma, nekas nevarēja notikt. Bija vēl mēģinājumi, un beidzot 95. gada tika 36 deputāti iesniedza iesniegumu Saeimas prezidijam par Saeimas ārkārtas sēdes sasaukšanu 95. gada 9. augustā. Rezultāts bija tas pats. Obstrukcija, līdz ar to, teiksim, likumu pieņemt nevarēja. Jāsaka tā, ka lielāko tiesu ar šo obstrukciju nodarbojās tolaik opozīcijā esošā partijas Latvijas Nacionālās neatkarības kustība, kā arī Tērzemē un Brīvībai, kur aktīvi iestājās. Un interesanti arī tas, es jums pieminēju Krastiņa LPSR konstitūcijas projektu ar nodaļu, kas veltīta konstitucionālajai tiesai. Tad Krastiņš viens bija no tiem, kurš ļoti aktīvi iestājās pret satversmes tiesas izveidošanu. Arī, kad bija pirmais lasījums par satversmes 85. pantu, ja viena daļa no opozīcijas vienkārši atturējās vai nereģistrējās, tad Krastiņš konsekventi balsoja pret. Ja? Tātad izteikt šādu pozīciju, ko viņš arī no tribīnas pauda, ka viņš ne. Kad tika ievēlēta 6. Saeima, un kad neviens no politiskiem spēkiem neieguva cerēto, proti, kad varētu diktēt spēles noteikumus, ir nepieciešami veidot koalīciju, tad visas politiskās partijas, kur tika pārstāvētas 6. Saeimā, deklarēja, ka viņi ir par satversmes tiesas nepieciešamību, ka tāda ir jāveido, bet sākās viss no gala, sākot ar satversmes 85. panta redakcijas pirmo lasījumu, satversmes tiesas likuma pirmo lasījumu, 1., 2., 3. lasījums, un, kā jūs redzat, ka tikai 96. gada jūnijā tika izdarīta grozījuma satversmē, proti nostiprināts satversmes tiesas konstitucionālais status, kā arī pieņemts pats likums. Līdz ar to bija jāsāk domāt par satversmes tiesas veidošanu kā tādu. Kā jūs atceraties, tad arī tagad satversmes tiesas likums paredz to, ka, lai kļūtu par satversmes tiesas tiesnesi, 2 kandidatūras virza ministru kabinets, 2 kandidatūras no tiesnešu vidus virza augstākās tiesas plēnums un 3 satversmes tiesas tiesneša kandidatūras virza ne mazāk kā 10 Saeimas deputāti. Pēc tam jāsaka arī tā. Tad, kad arī gāja vēl 6. Saeimas ietvaros pats satversmes tiesas likums, kā jūs zināt, tad sākotnēji tika paredzēts juridiskā darba pieredze tikai 5 gadus. Motivācija bija apmēram tā, ka tie vecie buki visi ir beiguši padomi laikā, ieguvuši augstāku izglītību, ka viņi nav spējīgi saprast satversmes būtību, ka būtu jāatlasa, šeit ir daudz jaunieši, ja, kuri ir beiguši jau ieguvuši augstāko juridisku izglītību brīvās Latvijas laikā, ka no viņiem būtu jāatlasa kā 15, 16 spējīgākie jaunieši, jānosūta uz rietumu demokrātijas valstīm, kur viņi papildus iegūtu šo izglītību, un pēc tam no viņiem varētu atlasīt satversmes tiesas tiesneši. tāda bija nostāda, tāpēc arī bija šī prasība 5 gadu darba stāžs, ne vairāk. Ja? Kad reāli nonācām līdz Satversmes tiesas sastāvu veidošanu, tad bija 2 kandidatūras, kuras virzīja ministru kabinets. Toreizējais ministru prezidents Andris Šēli veic tādu neoficiālu reitingu aptauju un deklarēja, ka 2, kuriem būs augstākais reitings, ministru kabinets virzīs kā Satversmes tiesneša amata kandidatūras. Saeimas deputāti uz šīm 3 vakantām vietām izvirzīja 6 kandidātus. Pie balsošanas tikai viens no viņiem, Romāns Apsītis, ieguva nepieciešamo balsu skaitu, tātad minimums vajadzēja iegūt 51 balsu. Tik ievēlēts viņš un tik ievēlēt abi ministru kabineta izvirzītie tiesneša amata kandidātus. Lai cik tas nebūtu paradoxāli, bet augstākās tiesas plēnuma virzītie tiesneši, tas ir Balskrājuma tiesas priekšsēdētāja Jūlis Kultāne un augstākās tiesas krimināllietu departamenta priekšsēdētājs Andrejs Lepsa, aizklātā balsošanā netika ievērota. Tas parādīja, manuprāt, vēlreiz šo politisko nostādni, ka cerēja, ka kaut kas tam līdzīgs būs. Bet tad šī balsošana bija aizklāta, līdz ar to, teiksim, kādi iemesli bija pamatā grūti pateikt. Augstākās tiesas plēnums atkārtot virzīja Lepses un Skultānas kandidatūras un otrā piegājienā tika ievēlēts. Tad bija mēģinājums viens no tieslietu ministrijas darbiniekiem tika virzīts kā kandidāts. Tai pašā laikā pret viņu bija jau ierosināta disciplinārlieta. Balsojumā par viņa kandidatūru nobalsoja nemaldos 12 vai 13 deputāti. Līdz ar to atļaut. Tad 10 deputāti, tai skaitā es, parakstījām iesniegumu, lai rekomendētu par Satversmes tiesas tiesnesi Anītu Šatsku, universitātes tolaik docenti, katedras vadītāju. Un varētu teikt tā, 96. gada oktobra un novembra ietvaros Satversmes tiesā tika ievēlēti bija 6 tiesneši, un 9. decembrī notika pirmā tiesas sēde, pēc likuma to sasauca toreizējais tieslietu ministrs, un līdz ar to, teiksim, 9. decembris, 96. gada 9. decembris ir Satversmes tiesas oficiālā dzimšanas diena. Bet tiesā ir jābūt 7 tiesnešiem. Satversmes tiesa gaidīja uz 7. tiesnesi vairāk kā 3 gadus. Līdz beidzot par 7. tiesnesi tika ievēlēts universitātes mācības spēks Juris Jelānis. Bet tas ir tikai 2000. gada laikā, kad beidzot Satversmes tiesa bija pilnā sastāvā. Jelānis nodeva uz vērestu valsts prezidentam 2000. gada 8. jūnijā. Bet, labi, tiesneši ir tautas nama. Sākotnēji tepat Aspāzijas bulvārī, kur pirms mums atradās toreizējās Demokrātiskās partijas saimnieka priekšsēža un ministru prezidenta biedra Ziedona Čevera birojas, kā pagaidu telpas, tur tika ierādīts Satversmes tiesā. Skaidrs, ka improvizēta sēžu zāle, tiesnešiem, tiesnešu palīgiem, darbiniekiem praktiski bija saspiesti un iespējas normāli strādāt nebija iespējams. Līdz ar to bija idejas arī, ka Satversmes tiesu vajadzētu ārpus Rīgas, lai nepastāvētu iespējamais interešu konflikts, ietekme Siguldā vai Jūrmalā, bet nav jau šādas telpas, kur būt. Tad bija piedāvājums arī tur, kur tagad ir Japānas vēstniecība. Bijām skatīties ļoti labi, skaisti, bet atkal tās telpiņas tik mazas, ka praktiski nodrošināt Satversmes tiesu ar nepieciešamo apstākļiem, darba apstākļiem, arī ar sēžu zāli praktiski nebija. Un tad man nāca zināms, ka Itālija, kurai bija rezervēta ēka, kur patreiz atrodas Satversmes tiesa, Kalnā ielā 1, kur stāvēja tukša, ļoti sliktā stāvoklī, ka Itālija atteicās no šīs ēkas. Un tad sākās cīņa, lai šo ēku varētu iegūt. Ne tikai iegūt, bet arī, lai iegūtu nepieciešamos līdzekļus renovācijai, lai varētu normāli funkcionēt. Un te jau atkal bija ļoti paradoxāla situācija. No vienas puses, jā, bet sākotnēji valsts nekustamā īpašuma aģentūra viņi būtu gatavi izīrēt, arī remontēt, bet piedāvāja tādu īres maksu, ko Satversmes tiesas budžets nespēja vilkt. Pie tam īres maksa līdzīgi ne tikai, teiksim, tur ir pirmais stāvs, otrais, bet arī pagārs stāvs, kur arī vēl šodien var tikai, tā, vismaz man ir ļoti stipri jāsačokurojās, lai varētu iziet cauri. Tāda paša maksa, kā, teiksim, par otro vai trešo stāvu. Tas būtu tā. Tad atkal ir valdības maiņas, bet vēl izdevās panākt to, ka ministru kabineta protokolā tika ierakstīts, ka ja, teiksim, šī telpa būs, un tam līdzīgi, tad arī parādīsies līdzīgi. Bet mainās atkal valdība. Ja? Pie ministru prezidents tā laikā ir Guntars Krass, Tērzemiešu pārstāvis, finanšu ministrs Roberts Zīle, patreizējais eiroparlamentārietis. It kā viss būtu skaidrs, ka principā valdība būtu gatava dot šo ēku Satversmes tiesai un ierakstīt viņu uz Satversmes tiesas vārdu. Kā valsts īpašums, bet uz Satversmes tiesas vārdu. Bet virzība, lai notiktu, finanšu ministram, kur pārziņā atrodas valsts nekustamie īpašumi aģentūra arī, ir jānāk ar šo ierosi. Nestoties uz Satversmes tiesas vēstulēm, nekas nenotiek. Es biju spiests griezties pie toreizējā valsts prezidenta Ulmaņkunga, kurš uzrakstīja vēstuli ministru kabinetam, piedraudēja, ka ja attiecīgais jautājums netiks iekļauts ministru kabineta sēdē, viņš būs spiests sasaukt ministru kabinetu ārkārtas sēdi ar šādu kārtību. Tik iekļauts. Bet ir pozitīvs rezultāts, kas notiek tālāk. Ministru prezidents Guntars Krass atsakās parakstīt ministru kabinetu lēmumu. Viņš ir pret. Tad toreizējais satiksmes ministrs Vildis Kristopāns, kurš bija arī ministru prezidenta biedrs, teica, tad es parakstīšu. Tas sākās. Galu galā viss šis process, kamēr vēl viss remonts, reāli Satversmes tiesa šajās telpās nonāca tikai 1909. Gada 5. martā. Ja? Tātad, kā redzat, nebija, ka Satversmes tiesas veidošanās process ritēja ļoti viegli un nekāda problēma nepastāja. Arī, es atvainojos, ja, arī pēc tam, kā jūs zināt, bija arī mēģinājums likvidēt Satversmes tiesu 99. gadā pēc 2 Satversmes tiesas nolēmumiem, kas likt nepatika valdībai, bet sabiedrība bija tā, kura kategoriski bija pret, un arī politiskie spēki norobežojās no toreizējā ministra prezidenta un toreizējā tieslietu ministra šīs akcijas par vēlmi Satversmes tiesu likvidēt. Tieši otrādi, Satversmes tiesas kompetence tika paplašināta, un Rodīs kundze varēja tikt pēc tam pie doktora disertācijas par konstitucionālo sūdzību. Paldies par uzmanību.
Paldies profesoram. Un kā nākamo runātāju es vēlos pieteikt mūsu kaimiņu valsts pārstāvu Latvijas konstitucionālās tiesas tiesnesi un tiesas priekšsēdētāju profesoru Žalus. Man jāatzīst, ka Lietuvas konstitucionālās tiesas spriedumi ir viena no visbiežāk izmantotiem spriedumiem Satversmes tiesā. Vismaz man ir iespējas radies, ka Satversmes tiesas darbinieki noteikti lasa šos spriedumus pirms raksta Satversmes tiesas spriedumus. Un vēl jāteic, ka arī studenti gan brīvprātīgi, gan piespiedu kārtā ir spiesti meklēt un analizēt Lietuvas konstitucionālās tiesas spriedumus, un daži no spriedumiem, kā piemēram spriedums Paksa lietā, kur gan profesors atzina kā ļoti garlaicīgu jau no rīta sarunām, ir visiem mūsu studentiem un arī, domāju, Latvijas juristiem zināms. Un jāatzīst, ka man pašai bija interesanti uzzināt, ka Lietuvas konstitucionālajai tiesai ir bijis jāatbild uz jautājumu, vai vispār konstitucionālā tiesa kā tāda, tās izveidošana atbilst konstitūcijai. Tā kā tas bija viens no interesantākiem spriedumiem, ko es pārlasīju. Bet profesors Žalums šodien referēs par citu tēmu, un tēma ir pamatvērtības kā neaizskarams konstitūcijas kodols. So, the floor is yours.
Thank you, Madam Dean. Madam Dean, dear Mr. President, dear colleagues, friends, ladies and gentlemen. First of all, let me thank you for the invitation to this remarkable conference. Secondly, I would like, on behalf of the whole Constitutional Court of the Republic of Lithuania, to congratulate all of you with a significant occasion, the forthcoming day of Latvian independence. Our states share a lot in history, and they share the same destiny and the same success. And 98 years old, it's also the age of Lithuanian state as well. And therefore we are destined, our destiny is to be together, to have the same challenges, and I believe to overcome all of them. Both external and internal, like was mentioned by previous speakers. And thirdly, what I would like to say in the beginning, I also would like to thank you for this timely publication of the book. I'm very happy because I don't need to read my presentation. Those who are interested in our jurisprudence, you can be familiar with all the details provided in my publication in this book. So, just to save the time, I'm going to stop on, let's say, key issues, maybe skipping something, and of course open to all the questions, and maybe explaining also what was behind those decisions of the Constitutional Court. As you can see, just trying to adjust my theme to the general theme of the conference. The theme is formulated like fundamental values as an inviolable core of the Constitution. And I will try to prove that in any case, even if the Constitution does not provide expressly, like the Lithuanian Constitution, it does not provide anything about inviolable values, I mean expresses values. It does not provide anything about, let's say, substantial limitations on amendment of the Constitution, like German Constitution, as was mentioned. But through means of interpretation, the Constitutional Court, I think, in any country is compelled to come to the same conclusion. So there are certain values, there are certain fundamental values, which form the inviolable core of the Constitution. Otherwise, the Constitution would be understood as providing the means to destroy the state, to destroy the constitutional order, and to destroy the nation. That's not, we believe, the purpose of the Constitution or its provisions. So, actually, what we have now as the doctrine of fundamental values, it's completely formulated in our case law, because, as I mentioned, there is no expressis verbis mentioning of unamendable clauses or any other limitations to amend the Constitution, but everything is subject to interpretation. Constitution cannot contain any gaps on any constitutional issue, including this one. That slide I will skip just in order to save the time, but coming to the essence, what list of fundamental constitutional values according to our case law? For first time we get the opportunity to address the question of fundamental constitutional values in, it's quite a recent doctrine. Maybe it's not accidental, I don't know, because just approximately from the year 2013, 2012, we got, let's say, emerging new threats to our values, both external, which I believe Islamic State and the Russian Federation, both internal. They are interrelated, of course, but like a match of populist movement, also populist ideas mentioned by previous speakers, and usually populism raises the ideas not consistent with European values, not consistent with the membership in the European Union. It's typical, I think, to many states. That's why the Constitutional Court had the opportunity to address the issues. And the first ruling, it was decision actually on inadmissibility, but the Constitutional Court had to formulate the doctrine on the validity of the acts of the Constitutional Court. And accordingly, again, looking to the text of the Constitution. Constitution is not only the text, but I'm not going to repeat maybe anymore. But looking to the text of the Constitution, the acts of the Constitutional Court gets a prospective value. They enter into force only after their official publication. And however, the Constitutional Court, when deciding on admissibility of one petition, just gets to formulate that the Constitution itself implies certain exceptions. And those exceptions are related to the values as they are listed here in Article 1 and Article 18. And the Constitutional Court proclaimed that if the Constitutional Court establishes that certain legal act, ordinary legislation, not so far about constitutional amendment, if certain legal act establishes the regulation or the rules that are in grave breach of fundamental values like proclaimed in Article 1, independence, democracy, and the republican form of government, the Constitutional Court can also proclaim all the consequences of this act arising from the date of its entering into force, all the consequences unconstitutional. That means that there is an exception for possible retroactive force of the act of the Constitutional Court, because otherwise an unrepairable damage could be done. Because if there is legal act that is in great breach to independence, to democracy, then all the consequences should be eliminated, including arising from the date of the publication of the act, not only from the date of publication of the respective Constitutional Court Act. And Article 18, you can see here, then innate nature of human rights and freedoms, why it is also attached here, because formally, again, looking to the text of the Constitution, Article 18 is not in the first chapter of our Constitution. And formally, it can be amended by the Parliament. But what is democracy? Good question. Democracy is not only the ruling of majority. We have in Lithuanian, I don't know how to translate this. Anyway, it will be not effective translation, but in Lithuanian we have the word demokratura. So democracy is not demokratura. Democracy is not democratic dictatorship. So that means that respect for inherent human rights is inseparable from the notion of democracy. That's why, although Article 18 formally belongs to the chapter which can be amended by the simple, not the simple qualified majority in the Parliament, but it's not so easy to state that. So you cannot amend this article just by parliamentary decision. You cannot deny this article by our amendments to the Constitution. And now we come another possibility to analyze and to formulate this doctrine of fundamental constitutional values. That was in 2014 when we get the case on constitutionality of constitutional amendment. And we proclaimed that one constitutional amendment was contrary to the Constitution, and in stating that, in reaching this conclusion, we get the possibility to formulate a doctrine that there are certain inherent implied limitations in the Constitution, and that is another principle that is implied from our Constitution as well, because both, let's say, four types of values, they are proclaimed in different articles. This one is principle of geopolitical orientation of the state. It contains two aspects. And now I will stop only on the first one, because it is expressly stated in one of the constitutional acts that is actually de facto unamendable. And it provides the prohibition for the Republic of Lithuania to enter to any post-Soviet Union, like Commonwealth of Independent States, like Collective Security Treaty Organization, like any other union formed by the Russian Federation, first of all, for the purposes to maintain something from the Soviet Union. And of course, prescriptive aspect is provided also expressly in our Constitution on the special Constitutional Act that, as an imperative, it provides for fully fledged membership in the European Union. And the Constitutional Court get the opportunity to explain, but although there is no express mentioning of NATO, but looking to the purpose of the Constitution, what is the best guarantee? It's not, I'm sorry, membership in the European Union, but it's clear membership in NATO. Once this category of transatlantic integration, until the membership in the European Union, it was expressly provided in the text of our Constitution, but later it was just formally replaced by this Constitutional Act on membership in the European Union. So that's why the Constitutional Court explained that looking to the purpose of our Constitution, geopolitical orientation in its prescriptive aspect means Lithuanian membership both in NATO and in the European Union, and also imperative to fulfill all the related international obligations. I'm not going to stop on, let's say, formalistic grounds, but actually there were two reasons why we, although it's not established by the text of the Constitution, why we established this special category of fundamental values. The first reason was that all these values, as I mentioned, independence, democracy, republican form of government, inherent nature of human rights and freedoms, and geopolitical orientation, they were established by the acts, let's say, adopted before the current constitution, by the fundamental acts of our state. Two declarations of independence, the first declaration of independence of 1914, the second of 1990, I mean the restoration of our independence, and the third act, that is the declaration adopted by our resistance movement, declaration of the Council of the Lithuanian Freedom Fight Movement in 1949. And you can see here clear orientation towards Western democracies. That's why we trace the tradition of our geopolitical orientation, namely from this document of constitutional significance. Just imagine, after 2 months from the adoption of the Declaration of Human Rights, the Lithuanian resistance movement expressed its readiness to commit to the values established by the declaration and appeals to the democratic world for assistance. That's why this declaration is also very important, and they are considered in our jurisprudence as pre-constitutional acts with supra-constitutional value. So that's why the mission of the Constitution, the purpose of the Constitution, because the Constitution is built on all these three acts, is protected, not to create conditions to destroy these values, but to protect them. That's why all the values that can be traced from these three fundamental acts, pre-constitutional acts of supraconstitutional force, they cannot be changed by any constitution of the Republic of Lithuania. And the second reason is, as you can see, here the act, just shortly to explain, the Act of Independence established that Lithuania should be independent and democratic state. Declaration of the Council of Freedom Fight Movement established respect for inherent human rights, geopolitical orientation, and repeated commitment to democracy, because we had authoritarian rule from 1926 to 1940, repeated commitment to democracy and to republican form of government. And the latest act on the establishment of the state of Lithuania just accumulates all these values. That's why we call them as the core of the constitution and constitutional identity. And of course, we can try to say that all the constitutions of all democratic states, they protect such values as independence, democracy, inherent human rights. That's why they can be perceived as universal values, and something what is specific to the Republic of Lithuania, that is republic and geopolitical orientation. That is not necessarily met in each constitution, but it is specific due to history, due to constitutional traditions of our state. But the second reason why we identified these fundamental values, namely these fundamental values, that is the constitutionality of constitutional amendments. We found that according to our constitution, looking to these pre-constitutional acts, there are certain limitations prohibiting to amend of the constitution in a certain way. For example, you cannot establish capital punishment because it would be inconsistent with respect of inherent human rights. You cannot introduce any form of, I don't know, dictatorship. That's why we said that there are certain absolute or eternal clauses. They are proclaimed by Article 1 independence, democracy, and what is inseparable, inherent human rights. Just because they were proclaimed already in 1918, and no constitution can provide any possibilities for denial or destruction of these values, because they believe that constitutional is not a pact for democratic suicide, let's say. And the second category, it's relative or conditional, but actually they are de facto unamendable. And why? That is just extract from our ruling explaining about eternal constitutional clauses. But that is de facto unamendable because they require 3/4 majority in the referendum. That's almost impossible to achieve. Really, it's almost impossible to achieve, and it has also its constitutional ground, because in 1991, in the circumstances of the Soviet aggression, if you remember January events, both in Vilnius and in Riga, in February, after Soviet armed attacks, there was the referendum in Lithuania which approved the first principle of the Lithuanian constitutional, approved or endorsed, it's better to say because already existed before, by the 3/4 of majority, both participated in the referendum, all the citizens of the Republic of Lithuania. And therefore, afterwards, the parliament, but before the adoption of the current constitution, adopted the special constitutional law, which is also currently a part of our constitution, that proclaimed that these principles can be changed only by 3/4 majority of all the citizens. That's, of course, so as you can see, and I'm going maybe to finish here. The third argument we also get in mind behind us, that necessity to protect universal constitutional values and democratic constitutional values follows also from some acts of international law, and we get in mind specifically Venice Commission guidelines for constitutional referendums, which expressly provide, of course, one can say that it's a soft law, but it's subject to interpretation. If we are members of the Council of Europe, if we are members of the European legal order, then it's clear that no question incompatible with essential values of the Council of Europe, such as rule of law, democracy, and human rights, no such question can be put even to the referendum. So that's why the constitutional clause, that's one more argument that supported our doctrine on fundamental constitutional values. And of course, just saying that all the values, they are perceived in very abstract and broad manner. They are not static concepts. Their content can be changed from time to time. And for example, I'm not going again to stop because we don't have the time, but according to the Lithuanian constitution, as it was interpreted by the constitutional law, for example, membership in the European Union is already provided in the constitution, by the way, but anyway, it is fully compatible with the principle of independence, because we consider the membership not as the loss or transfer of sovereignty, but only transfer of the competence, of the certain competence of the state organs to the common organs. But all the classic features of sovereignty, they still remains. There are no superior authority in Lithuania and the Republic of Lithuania except Lithuanian government. The Lithuanian government retains all the independence in international relations, and sovereignty is inseparable from pacta sunt servanda principle. But it depends, of course, on understanding, but that is official understanding of the Lithuanian Constitutional Code, and I'm not going maybe to repeat all the conclusions. You will be able to read them. But just what I learned and what I tried to prove, that even if certain constitution does not provide for certain internal or the core principles, they should be found. Of course, if there is possibility, you have such cases, by the Constitutional Court. Otherwise, the Constitution will be understood as the instrument not for a protection of the so-called universal or democratic values, but providing for a means of destroying those values. And that is incompatible with the very notion of the Constitution and with the notion of the sovereignty of the nation by way as well. Because once the nation refuses the sovereignty, even in democratic manner, even in the referendum, it's not possible anymore to regain them again in the same constitutional manner. So thank you very much for your attention, and of course I am open to answer all your questions, because it's not possible simply to cover all of related details. Thank you.
I think that everybody right now will be able to compare the jurisprudence of our constitutional court with yours, and it's obviously, I think, understandable that students will go further and will do presentations and also research papers about pre-constitutional acts with super-constitutional values. It is something interesting to learn, I think, altogether. Nākamā runātāja ir profesora Daiga Zevska, mūsu kolēģi, kur savu zinātnisko dzīvi ir veltījusi vispārējo tiesību principu pētniecībai. Vispārējo tiesību princips kā tāds tika, ja jūs atceraties, aktualizēts tieši pirmajā Satversmes tiesas spriedumā. Un iespējams daži no jums atceras arī komentārus, kas sako šim pirmajam Satversmes tiesas spriedumam. Proti tika pausts viedoklis, ja Satversmes tiesa nevar savādāk argumentēt, tad atrod Satversmes tiesai vien zināmus kaut kādus vispārējos tiesību principus un tad tos piemēro. Tagad Daiga Zevska ir arī līdzeklis tam, ka strādā Latvijas Universitātes Juridiskajā fakultātē, kļuvusi par Satversmes tiesas tiesnesi. Proti, viņa ir jaunākā Satversmes tiesas tiesnese, ar to saprotot, kā pēdējām no apstiprinātām amatām. Un šodien profesora tiesnesi, iespējams arī jaunākām, to, kad es nezinu, vai es izliekos, ka es nezinu. Šodien profesora Zevska mums dalīsies savās pārdomās par tēmu ideoloģiju, vērtības, tiesību normas un Satversmes tiesa. Lūdzu, vārds jums.
Good afternoon, dear dean, dear chairman, dear colleagues. The theme of my report is ideology, values, legal norms, and constitutional court. The central issue of this paper is to discover and detect the meaning, distinction between, and the logical legal sequence of the above-mentioned terms, as well as the relation of the terms to the meaning of the constitutional identity of the given state and its legal arrangement. First, the meaning of values. When we speak about the values, we usually hear or read such terms as life, human dignity, justice, family, freedom of expression or thoughts or choice, equality, democracy, human rights, rule of law, or even free market. But at the same time, often we hear that equality or democracy or rule of law are general principles of law. Thus, the terms, values, and principles in the modern legal theory seems not to have very sharp and precise borders for the distinction. To be absolutely clear, sometimes these terms are even used interchangeably. Nevertheless, there are certain and definable criteria to separate the terms in order to reflect their true legal nature
as well as the difference in the application while interpreting the Constitution. The values have a culturally determined meaning that provides it with a particularistic significance that effectively severs the idea of values from any universalistic claims. To prove this statement, the authors usually refer to the text of the constitutional documents, which in their turn refer to the values and the emphasis on the history and tradition. In these constitutional settings, judges must be attentive to societal values that are embedded in the nation's long-standing traditions and use them as a significant tool in the process of constitutional interpretation. There is still no one and unified definition for the term constitutional identity as well, as various authors place under the constitutional identity a wide range of concepts, from focus on the actual features and provisions of the constitutions, as for example, unitary or federal state, presidential or parliamentary system, to the relation between the constitution and the culture in which it operates, and to the relation between the identity of the constitution and other relevant identities, such as national, religious, or ideological identity. It should be taken into account that the constitutional identity cannot be reduced only to the written text of the Constitution. The elements of constitutional identity are reflected in many sources: the written Constitution, other laws and regulations, and other documents of non-normative effect, as well as in the unwritten general principles of law and values. The concept of the constitutional identity actually widens the scope of the Constitution, as the constitutional norms insinuate into the issues of the social values and political ideology. Therefore, references to the states, nations, history, traditions, language, conditions of the establishing and development of the country are encoded directly or indirectly in the constitutions. The preamble of the Constitution of the Republic of Latvia, called Satversme, clearly reflects those values which are the basis of the constitutional identity of Latvia. Among others, it states, I'm citing now, Latvia, as a democratic polity based on the rule of law, is a socially responsible and national state. It is founded on respect for human dignity and freedom, recognizes and safeguards fundamental human rights, and it respects its national minorities. The people of Latvia protect their sovereignty, as well as the independence, territory, unity, and democratic form of government of state of Latvia. Since times immemorial, Latvia's identity within the European cultural sphere has been shaped by Latvian and Livonian customs, the traditional Latvian way of life, and moral convictions. The Latvian language, as well as universal human and Christian values. Loyalty to Latvia, Latvian as the sole state language, freedom, equality, solidarity, justice, honesty, and the ethos of work and family are the foundations of a cohesive society. Everyone provides for oneself, one's relatives, and the common good by acting responsibly towards other people, future generations, the environment, and nature. End of citing. Such a beautiful legal text, right? I would call it legal beauty. I always have a goosebumps when I read it. Looking at the above-mentioned types of values, it appears that there is a difference between values like, for example, traditional Latvian way of living or Christian values, and for example, values like rule of law or socially responsible state. Taking into account the above mentioned, it has to be concluded that there are two types of values which are enshrined in the constitutional identity of the given country. First, Those are the values which are historically and culturally connected with the given sovereign. And secondly, those are the values which are introduced into the legal arrangement by the basic norm. In our case, democratic, rule of law-based state. Second, general principles of law. The values which are historically and culturally connected with the given sovereign serve as the basis for the sovereign when expressing its will in the form of the basic norm. Sovereign's will, in other words, defines the content of the basic norm. It speaks to the type of country in which the sovereign wishes to live. When sovereign's will is formulated in a basic norm, the legal arrangement in the relevant country is governed by the principles which emanate from that norm. In the case of democratic rule of law state, these are specific source of law called general principles of law. In deciding to create a democratic state based on the rule of law, the sovereign cannot affect the existence and content of these general principles of law. These principles then define the content and structural elements of the legal arrangement of the relevant country and are real and directly applicable legal norms, consisting of legal content and legal consequences and having generally binding effect. Those are the historical and cultural values which serves as a basis for a pronouncing of the basic norm, as well as the values introduced by the basic norm, needs to be protected by law. Law, which consists of unwritten legal norms in the form of general principles of law, and the written legal norms adopted by the legislature. So the values are the basis of law. The aim of law is to protect them. Third, ideology. Ideology is a collection of opinions and beliefs held by an individual, group, or society, and that guides them. It is a system of ideas and ideals which form the basis of the theory, and in our case, we speak about the theory of the democratic rule of law-based state. It is very important to acknowledge that common ideology, common system of beliefs in the given society is crucial for the protection of democracy and the rule of law. And it applies to both sovereign and those who apply legal norms. Where the validity of the basic norm rests. The validity of the basic norm actually rests in the assumption of persons applying the law. The assumption of the basic norm is an assurance which rests in the legal mind or consciousness on the mandate and righteousness. The basic norm makes those who apply legal norms feeling safe and faultless when they are acting in the framework of the mandate. And it is not enough to know the basic norm. The one who applies law has to believe in it. The ideology held by the sovereign primarily reposes on its historical and cultural values, which connects with the values introduced by the basic norm. However, on the other hand, the ideology of the democratic rule of law-based state needs to be promoted and, I would say, popularized to the sovereign. Education is very important in this regard, and I would like to stress the so-called educational function carried out by the Constitutional Court of the given legal arrangement. We all have heard the saying that the legal arrangement is as strong and as successful as its Constitutional Court. The role of the Constitutional Court in the developing and maintaining of the democratic rule of law-based legal arrangement cannot be overrated. And we can be regarded as lucky here in Latvia because we had such an open-minded and ready to apply unwritten legal norms, general principles of law, even if it's first judgment constitutional court. I dare to insist that this first judgment of the Constitutional Court of Latvia, delivered almost 20 years ago, accelerated the development of Latvia's legal arrangement towards democratic rule of law based arrangement governed by the legal understanding based on the natural law doctrine. Of course, one can argue that the legal arrangement would come down this path anyway, but certainly not as fast and not in such a quality as for today, as we can enjoy right now. To sum it up, there are two types of values which are enshrined in the constitutional identity of the given country. First, the values which are historically and culturally connected with the given sovereign, and second, the values which are introduced into the legal arrangement by the basic norm, in our case, democratic rule of law-based state. Secondly, the values are not legal norms, but they are reasons why the legal norms exist in the legal arrangement, and namely, to protect these values. It leads to the next conclusion, that the aim of the legal norm is to be applied in such a manner that protects the values in the best possible way. Thirdly, ideology is a system of opinions and beliefs which serves for the protection of democracy and the rule of law, on the one hand, by providing the basis for the assumption of the basic norm and believing it of those who apply legal norms, on the other hand, by being an educational basis for the sovereign to apprise and use legal arrangement. The role of the Constitutional Court in this process is crucially important. Thank you.
Paldies profesorai Rezevskai par vērtīgu visaptverošu skaidrojumu. Un nākamā runātāja profesora Papiešvili pārstāv valsti, kas vienmēr rada siltas jūtas ikvienā Latvijā. Un tā ir Gruzija. Ar profesoru Papiešvili es iepazinos vizītē Gruzijas valsts universitātē. Jāatzīst, ka profesori darbojas citā sfērā, proti viņas pētniecības lauks ir saistīts ar kriminālu procesu, taču vienlaikus profesori Papiešvili ir arī Gruzijas konstitucionālās tiesas tiesnese. Un mums ir liels gods un prieks redzēt viņu atgriežamies pie mums juridiskajā fakultātē, un katrā ziņā vienmēr ar profesori ir liels gods un prieks sadarboties arī citos projektos. Un šodien profesora Papiešvili dalīsies pārdomās par mūsdienīgu perspektīvu līguma interpretāciju, meklējot jaunu paradigmu Gruzijas konstitucionālajos nolēmumos. So, Professor Papiešvili, the floor is yours.
Good afternoon. I know that everyone is tired and we are slightly overscheduled, so I will try to be as short as brief as possible. And in the beginning, first of all, I would like to congratulate our hosts for the upcoming National Day, and I wish all the further success in private lives and for Latvia as a whole. Today we are discussing constitutional values, and I will try to stress not only fundamental rights, but to give a brief overview of the recent case law and to briefly touch upon the major challenges that usually constitutional courts are facing. Constitutional Court has faced numerous cases in different subject matters, which over time have revealed deficiencies in practice and encouraged the courts to take an active role in changing the essence of constitutional proceedings. Application of the law in practice, as well as gap in legislative regulation, lead the court to introduce new approaches. I will try to present a number of landmark cases from our case law that proved to be a turning point in a constitutional adjudication in Georgia. First of all, I will try to describe the constitutionality of Begu legislation. In 2007, the court assessed the constitutionality of Begu legislation. The case concerned the law of the right to investigatory activity, according to which this activity was allowed only by the order of the judge or on the basis of a written application of a victim, or if there is a data of an illegal conduct for which criminal code established imprisonment for no less than 2 years. According to the constitutional complaint, the norm violated right to privacy as it allowed different interpretations, especially the conditions following the conjunction or could each be applied cumulatively with the first condition of the same norm or as independent alternatives. The court decided that the legislator is under duty to pass legislation that is foreseeable and unambiguous. The quality of the law requires that legislative regulation is so clear that an individual can comprehend his or her legal situation and act accordingly. Together with accuracy, foreseeability, and accessibility of the law, another essential condition is that the scope of permissible interference into the right must be specific and clear. Therefore, the law should clearly and in sufficient detail define the powers of public authorities and shouldn't allow the public authority itself to define the scope of its permissible action. Citizens should know in what circumstances and on the basis of what grounds their rights may be restricted. They should be able to enjoy the right to apply to the court. Therefore, courts set the standards that a legal norm is unconstitutional if only one of its interpretations could give rise to a threat of violation of a constitutional right. Another challenge and another major direction of our case law is the narrowing the meaning of a legal norm, especially defining the normative content of a disputed legal act. Since Georgia adopts constitutional review model, inconsistencies between the practice of ordinary judiciary and the constitutional court happens to be noticeable. Despite the constitutional court is not required to take into account the interpretation of the common courts, it began to give the common court's interpretation an utmost account. It was believed that ordinary judiciary, whilst considering actual cases in practice, were better served to effectually legal norms in practice by giving the particular meaning. This meaning then must be assessed by the Constitutional Court as a substance of the norm in question, as it did not need to go on with its interpretation, because doing so might have caused the Constitutional Court interpreting a law differently from the ordinary judiciary and adopting a decision which could hardly be enforced in practice. As individuals are directly interested in getting an effective remedy, ignorance of common court's interpretative practice would have made the constitutional justice inert. The Constitutional Court changed the approach of assessing the constitutionality by defining a particular normative content problematic to the complaint within the disputed law and evaluating its constitutionality. Court used this approach in a number of cases, among them judgment concerning prohibition of use of hearsay evidence. Especially, court stated that the use of hearsay for charging and conviction purposes is unconstitutional. However, use of hearsay for any other investigation purposes has been declared constitutional. The third problem was the legal gap and constitutionality of legislative institution. In a recent case, the court assessed the number of legislative provisions related to the rights of persons with mental disabilities. Especially, the court determined that articles which include every single deal negotiated by a mentally disabled person, including deals that benefited these persons, trespassed the aim to defend the persons with mental disorders and were disproportionate restrictions and violated rights to personal development. Norms that enacted the status of being recognized as incapable and replaced the individual's work with his legal representative were not justifiable means aimed at taking care of the person recognized as incapable. The existing approach was completely ignoring the reality that the limitation of mental disorders is characterized by the wide-ranging gradations of limits and limits the ability of persons with mental disorders to comprehend the results of their actions to a varying degree. The disputed norms, however, were applied to all persons recognized as mentally incapable and took away from them the possibility to realize those capacities which they did still have. The court pointed out that an optimal mechanism to recognize a person as incapable should allow a court to consider the damage on the decision-making capacity of a person with mental disorders and must ensure as much as possible that the rights and freedoms of this person are protected. The purpose of guardianship lies in supporting the person and not in substituting their will in everyday life. Therefore, development of personality of persons recognized as incapable were declared and the norms were declared unconstitutional. The court also reviews the norms that restrict incapable persons' freedom to choose the psychiatric care facility, a doctor, and decide the commencing treatment. The court pointed out that the right to self-development includes the right of an individual to submit him or herself to this or that kind of treatment, choose a doctor and a care facility. When a person is incapable to give informed and free consent to the treatment plan, interference in the right is permissible if this will benefit the welfare of the person in question. However, when the person is capable of consenting independently and in an informal manner, any interference on his or her health shall require consent. Since recognition of incapacity does not involve measurement of the level of mental disorder, a person is unconditionally excluded from medical decision-making that will affect his or her health, which results in ignoring his or her rights. Therefore, this approach was declared unconstitutional. Court also declared unconstitutional regulations according to which only guardian and doctor were entitled to apply to the court and ask for restoration of capacity. Therefore, incapable persons had no right to independently apply to a court with the same request even when they have recovered. The court determined that a person recognized as incapable must not depend on the goodwill of his or her legal representative, family members, or psychiatric care facilities to be able to enjoy the right to appeal to a court, a right that will protect these persons from abuse of discretion. The above described norms were also declared unconstitutional. According to the Civil Code, marriage was prohibited if one of the future spouses were recognized as incapable. The aim of this disputed norm was to protect persons recognized as incapable from forced marriage and protect their right to property. The court found that it was possible to establish at least restrictive measures achieving the aim by a law of marriage through the consent of legal representative or respective body. If a person has social skills to understand non-material results that accompany a marriage, which is not established at any moment when the recognition of incapacity takes place, then taking away the right to marry represents a disproportionate interference into the right. Therefore, without taking into account the individual mental capacities, restricting the right of the person recognized incapable was also declared unconstitutional. More recently, the complaint disputed criminal procedure code, which allowed for the imposition of 9 months of detainment per each criminal case when these cases were related to criminal crimes committed prior to be taken in custody. First, the Constitutional Court interpreted Article 18 of the Constitution, according to which the term of detention and remand of accused shall not exceed 9 months. Unlike in prior judgment of the Constitutional Court from 2003, the court believed that 9-month guarantee doesn't terminate the injunction when the defendant has submitted to his case to court. The goals of applying detention remain unchanged during the entire duration of criminal prosecution until the defendant is acquitted or convicted. Therefore, the court stated that on occasions where several accusations are simultaneously indicted, to determine the maximum dates of detention on remand, the time the defendant spent in custody after he was charged in other crimes must be taken into account. Therefore, it was also called unconstitutional to apply detention on remand against a person from the moment he spent in court to 9 months after he was initially indicted in any criminal cases. The court noted that the law does not preclude requesting detention for those criminal cases which were committed by a person after he was placed in custody or were committed prior to detention, but appropriate evidences were only revealed after he was placed in custody. Additionally, constitutional aims preclude artificial breakup of cases with the goal of prolonging the duration of detention or new grounds, for example, appropriate facts, information, etc., for criminal prosecution that had become known for the prosecutors and they were sufficient to indict the person. So that was a really very brief overview of the recent case law. Thank you all for your attention, and I wish you everyone a pleasant evening. Thank you.
So, tātad mēs esam noklausījušies visas prezentācijas, visi referāti ir izskanējuši, un tagad laiks debatēm. Es ceru, ka jums ir radušies kādi jautājumi, vai arī jūs vēlaties izteikties par apskatītiem jautājumiem. Yes, please. You have micro. You have to speak in micro.
Okay, thank you. Is it okay when I stay sitting? Yes, my name is Madis Ermits. I come from Estonia, and my presentation is tomorrow. Somehow it would have fitted here, but it doesn't matter. I thank you very much for this very rapid overview of the Georgian system of constitutional review, and I thank you very much, Professor Engins, for this view back to the beginnings, and I would really like to read an English or Estonian translation of this, because it would, I think it would be useful for our discussion as well. Thank you very much, Professor Rezerska, for this presentation. We have learned that constitutional theory or constitutional law in nowadays Latvia is a very beautiful subject. Thank you for this. But my question goes to Professor Zalimas, and I think if I consider the differences and the aspects that are common in our countries, then if I understood all the speakers correctly, and I consider Estonian system, then our system has very much in common with Latvian system on the basis of these fundamental values. What I didn't hear in your presentation, Professor Zalimas, were the concepts of rule of law and social state. And the first question is, do you treat them as constitutional fundamental values or not, or what role do they play in your constitutional interpretation? And the second question concerns the social contract, which you meant 2 times. I mean, theoretically, the social contract is just one of many ways of justifying the state, and it's a rather controversial one. Is this the official point of view of Lithuanian doctrine? Question mark. Thank you very much.
Thank you for your questions. So maybe you can repeat, it could be easier than the translations. And afterwards, you will start.
Thank you for your questions. Indeed, with pleasure, I would answer you. No. Values are universal, but the language of the constitutions can be different, yes? So that's the case of Lithuania. Why I didn't mention, for example, the rule of law. What is democracy? Does it comprise the rule of law or not? Of course it does. But the rule of law as separate value is also enshrined not in Article 1, in the preamble of the Constitution. That's why, of course, for example, amendments to the Constitution that would be contrary and deny the essence of democracy, of course, at the same time would deny the rule of law. That's unquestionable, I think. But just looking formally to what was established by the pre-constitutional acts and what is required under the amendment procedure, as established in the Constitution. So, Article 1 is specifically mentioned, and not the preamble as such. And in Article 1, you can see only democracy. Let's say, but democracy without the rule of law, it's impossible, I think. And the second question was about
social contract.
Social contract. The constitution is the social contract, you mean, yes? That's perception. Yes, that is our official perception that the constitution is a social contract. Maybe it can be explained by the fact that the current constitution that is enforced, paradox, of course, our state is 98 years old, if we speak about the current state of Lithuania, and the current constitution now is enforced for 25 years. Next year it will be 25 years, and it's the only constitution that was adopted by a referendum. And we see that as a value, anti-majoritarian character of the constitution, because the parliament was successful in reaching political compromise on the text and putting it to the referendum. That's why maybe, of course, it was done from the first, let's say, rulings of the Constitutional Court, but the Constitution was defined as, first of all, as a matter of social contract, which obliges all the members of the society and the civic nation as such as well. So that's, yes, that's official point of view. I fully aware that it could be possible to take another one, but it's simply, I'm explaining why in Lithuania this one is prevailing.
Thank you. Thank you, Professor Jonas. So the next question, yeah. So, on the bottom, I think. Just try. Maybe it's bullet.
So, my name is Stefan Manko, University of Amsterdam and University of Poland. I have a question to Mrs. Justice Rezewska. I enjoyed your paper very much, although I think you painted a very beautiful picture, but I'm not sure if this picture is realistic in the sense of ideological and axiological uniformity, homogeneity of society. I do not know enough about the Latvian society. Perhaps you Latvians share the same values and the same ideology, all of you. But in Poland, at least, we have very deep ideological conflicts, for instance, on abortion, on gay marriage, on protection of tenants versus protection of landlords, and so on and so on. And our Constitutional Court is taking deeply political decisions. So it has to choose between conflicting ideologies. And I'm wondering, how would you comment on that from your practice as Justice of the Constitutional Court of Latvia and as Professor? Thank you.
Thank you. May I ask you to come here?
Can I have that
you pass a microphone?
Always in my life, I would love to
like
talk to that
yeah,
microphone.
sure.
Feel myself as a star, singing stuff. Thank you very much for the question. There are so many things actually needs to be addressed from that question. I will tell only what I want to. I mean, not about all the things you asked. That's my privilege, you know, when I have a mic and I answer the questions. Mrs. Rodiņa, our dean, she already, when started to introduce me, she said that all my scientific life, actually, what I have done is thinking about how it has to be. You know, there are very many people in all countries all around the world who are thinking about what is. I am thinking about how it has to be. And actually, also the theme of my dissertation was axiological aspects of general principles of law. And in that sense, I can say that legal arrangement of Latvia has done a great job, a really great job, because in particular, if we refer to the issue of general principles of law as the unwritten, But directly applicable legal norm, I think, in those 20 years since we started to just think or write about general principles of law, which should be recognized as a source of law in the rule of law-based democratic legal arrangement, which should be applied directly, not looking whether they are written into the legal text of normative legal acts or they are not written, not taking that into account. And then we even have this beautiful, again, written legal norm in administrative procedure law, which states that legal norm is normative act, part of it, and general principles of law. So in that sense, I can tell you that there is no any discrepancies between the theory or axiology and the practice. And if you look at the judgments of the courts of regular jurisdiction, I'm not even talking about the constitutional court judgments or about the Supreme Court judgments, but the lower level courts of general jurisdiction, you can find general principles of law, unwritten legal norms applied and concretized to resolve the given case in a just and reasonable manner. So this, about my practice as a justice of constitutional court, I would love to answer that question in 5 years maybe, as I started just now. As you heard, I'm very young in all senses. So I started April 26th, and yeah, and that would be a really huge question, but of course we can discuss it later if you would like. Thank you.
Thank you, Professor Rezevsky. So, Professor Plagatis also would like to make some comments, please.
Thank you very much. In fact, I'm truly enjoying an excellent discussion, and I'm thankful to be invited to be here. You said the values are not norms. However, the values have normative power. And this is the importance of values, and this is the importance of the theme which you chose for this year. In a few words, let us remember that in the 19th century, what was important was democracy. And if you asked in those days, he as a politician, to choose between being in the parliament or being a minister, he would avoid to be a minister. He would be in parliament because that was the place of the political life, that was the place where a politician could offer. After the Second World War, we passed from democracy to governmentability. The first value in all constitutions is governmentability, and democracy and the parliaments went to a second rank in comparison with the government and the ministers and the prime ministers and the heads of states, perhaps. And there come the values, because as the Germans have developed since Buckelfelde, I think, it's the democratic principle which is most important today, more than the democracy itself, which transcends all the society, all the constitution, all the public life. And in the democratic principle, you have reflected all the values of a society, including the wonderful values which you enumerated of this country and which I truly enjoy. Thank you very much.
Thank you, Professor Plagatis. Professor Jonas, Professor Rezevsky, would you like to?
No, I think that was a comment.
Just to add something, Lithuanian Constitutional Court, some 5 years ago, I had the case related to moral values, where we were accused of taking political decisions going against traditional moral values, Christian values, and so far. That was a state family concept case, because our parliament in 2010 or so adopted the state family concept, according to which family was defined only as based on registered marriage. And of course, then the Constitutional Court, yes, to take the position. But their position, I don't call it political, it's first of all legal, then moral, because the Constitutional Court had no other opportunity as to recognize this definition as being unconstitutional based on two reasons. First of all, a literal interpretation of the Constitution, because marriage is mentioned separately from family. Maybe those who drafted the text of the Constitution, they had imagination some 25 years ago that it's the same, but it's not the same. And then we explained, if we are part of Europe, then the notion of family should be European notion. And that is European consensus on not on gay marriage, but on the concept of family, that it cannot be narrowed only to the basis of registered marriage. But of course, we get very fierce criticism. Even now, there are certain amendments registered in our parliament to, as they call, to rectify the damage made by the Constitutional Court to our Constitution. But nobody knows, maybe this constitutional amendment then would go to the Constitutional Court again. Because we get this. All the time, yes, it's the fight maybe between different ideologies, but on the other hand, you know, even traditional and Christian values, they suppose, to my mind, tolerance. Today is the day of tolerance, so that's why let's be tolerant to different forms of. Okay, thank you.
So, thank you, Professor Žalmes. Anybody, vai vēl kāds grib izteikties? Jā.
So, question, what happens when the constitutional values change over time? Why I'm asking this is because I recently had the situation where I had to present a paper to some students, and I asked them, do you think it would be possible or acceptable in certain situations to do things that are unspeakable, for example, torture? And most of them said yes. So I could understand that over time, due to processes in our society or the world, some values could change. So what happens when it does that? Whether this changes is constitutional or not?
Thank you for a question. So can you please pass the microphone? Thank you.
We can both.
Who will start the first one?
Guest goes. Yes. Guest go first.
Lady first, maybe, but thank you. You know, as I tried to explain, no value can be understood as having, let's say, static notion. As I explained, maybe 25 years ago, the drafters of our Constitution really understood the family only as based on marriage. But now it's 21st century, and we are moving forward with protection of family life, and of course, no more, unless of course the text of the Constitution clearly provides the opposite. The Constitution, even the Constitution can be reinterpreted, because the Constitution should be viable, and viable if the text allows, if it is flexible for adjustments. And therefore, we have even a special doctrine that even the Constitutional Court can change its stand, and it did on a few occasions, for example, on the principle of equality, but then it does increase the protection of human rights, increase human rights standards. You should prove that, and you can change the official constitutional doctrine, of course, if the text of the Constitution does allow it. But speaking about torture, I cannot imagine any situation that the torture can be legalized or so, and it's my firm stand that, you know, as I told you, inherent human rights, they cannot be denied even by the constitutional amendment. So if I imagine, I don't think that it's possible in Lithuania, for example, but if somebody would like to legitimize some sort of torture by introducing constitutional amendments, that constitutional amendment would not stand the test of constitutionality.
Thank you very much.
May I everything so well said. It's all right. I'm not going to say anything.
You want to? Yeah.
I'm not going to say anything. I'm not going to say anything too important. But you said that Constitution is a living Constitution.
Yes, of course.
Now, I will just to make you laugh. The Greek Constitution is proclaimed in the name of the Holy Trinity, not in the name of the people, not in the name of anybody else, in the name of the Holy Trinity. No one touches upon it, no one dares touch upon it, and no one reads it, because it's a living Constitution. Do you see what I'm saying? When they did it in 1822, it had a meaning. Those were the ones who took the arms. But today it has no meaning. They don't change it. But it is a living Constitution. It has no normative value whatsoever.
The entire world is based on the Holy Trinity, actually. So maybe there is some kind of connection anyway. Yeah, actually, you happen to be the third person over the last year who asks me this question about the torture. Maybe you know why.
That was an example.
Why people are asking more oftenly now in our days this question?
No,
why did you ask to your students this question?
No,
why even you had in mind such question to ask to your students? Okay, yeah, I think colleagues already answered that, of course, everything is changing. Legal arrangement is changing. Legal understanding, meaning of law is changing every single day. Unwritten legal norms are changing faster than written legal norms, but all of them are changing. And as our poet Rainis said, pastāvēs, kas pārvērtīsies. I haven't thought about that in English. I believe translators will help me with translation of that. So, what I wanted to say, Latvian language is not the same as it was then when the Constitution was drafted. And even Latvian way of living is not the same anymore as then, you know? So values are changing, and of course we are changing together with them, or they are changing together actually with us. And let us not just try to provoke each other with these in abstracto collisions of general principles of law as a basic legal theory, which we all know states that you cannot resolve the collision of general principles of law in abstracto. Give us, given case, factual situations, two general principles of law in a form of human rights, and we will do our job. We will balance them according to the development of legal arrangement. You cannot answer that question in abstracto. That is my answer. Thank you.
Thank you, very good answer. Thank you for that. And es domāju, ka šodien mēs varam noslēgt savu sesiju, un es gribu pateikties visiem runātājiem, profesoram Enziņam, liels paldies par gremdēšanos vēsturiskās atmiņās, profesoram Žalimam paldies par Lietuvas konstitucionālās tiesas jurisprudences skaidrošanu, profesorai Rezevskai liels paldies par vērtību definīcijas iedošanu, un profesorai Papiešvili liels paldies par Gruzijas konstitucionālās tiesas prakses skaidrošanu. Un es gribētu noslēgt šīs dienas sesiju, sesijas sēdi ar vienu ļoti jauku Eiropas cilvēktiesību tiesas tiesneša citātu, un tas ir tiesnesis Leksgarlickī no Polijas, kurš ir teicis par konstitucionālām tiesām šādu, un es ceru, ka jūs pievienosieties šim te secinājumam, proti, ka konstitucionālās tiesas ir viens no veiksmīgākajiem tradicionālās Eiropas demokrātiskas un tiesiskas valsts uzlabojumiem. Paldies jums visiem par uzmanību un tiksimies rītdien nākamajās sekcijās un sēdēs. Paldies!